court, 13th century, all the records were destroyed by fire.
Yes.
So I have already mentioned at the time of judgment, my lord said that you get the certified copies. I have applied for certified copies, but my lord, the certified copy department did not allow me to.
Anyway, if that you take it, you talk with the register administration. The necessary orders will be, necessary direction will be given.
Direct me.
No, you just meet the register administration for
They
that
have
purpose.
supplied, but paper book and supplementary.
Okay, the matter is disposed. Okay.
And
Now, if you are not
it was
getting
only pending, actually lower court. It
very
was
well, so here the matter
Yes,
is
yes.
disposed.
Yes.
So if you don't get the certified copies, you lodge a complaint before the register administration. So he will look into the matter.
All right.
Lordship, maybe
With your lordship's leave, an application, agency, as 24 years, this appeal, second appeal was admitted, in 2023. After, such, the application.
Second appeal, which year? This is
2023. Now, after this long years of 2024, they are forcefully, unnecessarily disturbing the possession. I had to file an application. I was, like mentioned before, your lordship, before vacation, your state.
no application. Second appeal is to be heard out.
Yes. Any day convenient to us.
Let it appear as to be mentioned.
As your lordship, as I.
Thereafter, date will be fixed.
Grateful.
Lordship, may I be permitted to mention a matter, Lordship? Lordship, I'm mentioning upon notice for extension of interim order. Lordship, the interim order is expiring on 12th.
Okay, to be mentioned.
Grateful, Lordship.
Kind leave, my lord, to mention upon notice, my lord, a Jalpaiguri Circuit Bench matter. My lord, I had mentioned this matter on the 22nd of May.
So is it a part-heard matter by me?
No, my lord, it
Then-
has been made, two matters were being, my lord, heard analogously, in which one matter was made CAB. Subsequently, in the other matter, an application for recalling was filed. Now, my lord, I must indicate that on 22nd May, my lord, I had mentioned.
When is the matter due to appear?
Today it was due to appear, my lord, it is not appearing in the list.
Anyway, give the slip.
I'm so grateful. my lord.
For inclusion in the list.
Inclusion?
Application matter.
Yes.
With the lordship leave, may I be permitted to mention one application for inclusion in the list.
Application for
Is a second in connection with the second appeal, your lordship.
correction?
In connection with the second appeal, your lordship.
No, what application?
An application for substitution, your lordship.
Yes.
Then the application for non-prosecution.
Yes. Non-prosecution, let it appear as to be. Have you filed an application? Or simply is it a non-prosecution? Okay, to be mentioned, non-prosecution.
I'm for the claimant.
Okay, this is application for
Application for restoration.
a copy served upon.
I have served the copy. My learned senior friend is at home.
The brief.
Book is also ready. And one for restoration.
Committee push.
This is can one.
And one.
No, Misro. No. I'm Patro. No, I'm sorry, my lord. I'm not in this one.
This is with regard to which insurance company?
National Insurance Company.
If somebody has already entered, then it's a different.
Then my lord will kindly keep it not today. Let me just take instructions because it's restoration application.
Otherwise, you can appear on the next day.
On the next, I'll just take instructions today. If somebody is appearing, my lord, I'll.
Okay, I'm just making it not
Fine,
today.
fine.
May I file the paper book? Or
Let it be restored on the next day. You file.
Yes, sir. 41.
41, yes.
My lord, I am for the respondent.
What is this application for?
Application for condonation of bill.
Condonation of delay. So how many days delay? Okay, let me see the record. Have you been served with a copy of the application? Let me see.
Amit Ranjan Rai is the
Just a minute, let me see. A 117 days delay, let it be condoned.
Yes.
So that the paper book's direction can be issued. Yes, record an order. This is an application for condonation of delay filed by the appellant petitioner. Peruse the petition filed and the materials on record. Upon perusing the petition, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and this appeal is admitted. As the respondent, New India Assurance Company has appeared, service of notice upon the respondent New India Assurance Company Limited is dispensed with. Let service of notice be caused upon respondent number 2, Dipanjan Rana, vehicle owner. The trial court records be called for and the paper books be filed upon arrival of the trial court records. Service upon the respondent number 2 be caused personally as well as through the department by filling up necessary requisites. Liberty to mention after 5 weeks. Can one is disposed.
But I am on behalf of the appellant. The can is for condonation of delay. Delay about 182 days.
You are for the respondent. Yes, record an order.
And my lord, kindly allow me, my lord, to file paper book. Only point equal future proceedings.
Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates, peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and this appeal is admitted. As the respondent number 1 has entered appearance, service of notice upon respondent number 1 is dispensed with. Let service of notice be effected upon respondent number.
Did not contest.
Let us see, we serve him.
No, my lord, the respondent number 2 has no role, has no role to play. Because it is only.
Service upon respondent number 2 is dispensed with. Upon respondent number 2 is dispensed with. Have you incorporated all the trial court records?
All the trial court records.
The paper books be filed. Paper book file be kept with the record.
And one copy has been sharp.
Let this matter appear as to be mentioned after 2 weeks.
Kindly fix the date, only future posting.
Okay. This is a matter of 2026. Wait for some time.
2 weeks.
The accident took place by 2016.
Come after 2 weeks, let it appear as to be mentioned. I shall thereafter fix the dates.
That's 553 দিন দিটা। দাঁড়াও।
This is also one application for condonation of delay. This is affidavit of service. I have served by the company. Let the delay be condoned. I have explained the manner the delay in paragraph 5 onwards.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents. You have served both the respondents.
Yes. Now, I am serving only upon the insurance company.
Okay,
It is also
respondent.
the quantum.
Respondent number none appears for respondent number 1 insurance company in spite of service of notice.
Affidavit service 5.
The affidavit of service filed be kept with the record. The application for condonation of delay is taken up for consideration. Heard learned advocate, peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned. The appeal is admitted.
I am filing the paper book.
Okay.
I will serve
Okay, let service of notice be effected through the department upon the.
No, my lord, I am served directly upon the insurance company.
Did they appear?
My lord, possibly Mr. Singh or Mr. Pari or anything. I have inquired.
Let this matter, the appeal is admitted. Let this matter appear after 2 weeks as to be mentioned.
Paper book file be kept.
The paper books file be kept with the record.
Okay.
44, I am for the respondent number,
44, you are for?
respondent, my lord.
What is this application?
I'm just praying for not this week. I'm for the petitioner. I have a pending section 5 application.
Okay, not this week.
And I am for the petitioner, my lord. This is my application for condonation of delay and stay. My lord, your lordship, on 7th April, your lordship directed me to serve the copy of the condonation of delay and matter will appear 2 weeks. My lord, I had served, my lord.
দেখি রেকর্ডটা how many days delay
My lord, 178.
58 days
150.
yes record an order learned advocate for the appellant is present none appears for the respondent in spite of service of notice the affidavit of service filed be kept with the record the application for condonation of delay is taken up for consideration. Heard learned advocate for the appellant. Upon perusing the petition and upon hearing the learned advocate and considering the period of delay, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 18 June 2025, passed by learned additional district judge, second court, Durgapur, Paschim Bardhaman, for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents, both personally as well as through the department, by filling up necessary requisites. The trial court records be called for.
Department, Registrar General is directed to invest.
Yes.
Registrar General is directed to invest the amount.
ওই একটা করে দেবেন হ্যাঁ রেজিস্টার জেনারেল ইজ রিকোয়েস্টেড টু ইনভেস্ট দ্য অ্যামাউন্ট ইন এ ফিক্সড ডিপোজিট হ্যাঁ ওটা মাঝখানে ঢুকিয়ে দেবেন ওই দি আচ্ছা the appellant shall take steps to cause service of notice both personally as well as through the department by filling up necessary requisites. Stop. The trial court records be called for and the paper books be prepared on arrival of the trial court records. Liberty to mention.
My lord, item number 46, my lord, is the appeal of the insurance company, my lord. But this is an appeal arising out of the, my lord, Employees Compensation Act, my lord. Lord, I have filed 2 applications, my lord. Can 1 is for stay and Can 2, my lord, is for condonation of delay.
No, after condoning the delay, the matter will go to the division bench. Have you caused service upon
Yes, my lord, I have caused service, my lord. This is my affidavit of service, my lord.
How many days delay?
My lord, 255 days delay.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. The application for condonation of delay is taken up for consideration. Heard learned advocate for the appellant perused the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Stop. Thus, delay in preferring this appeal is condoned. Stop. Let the matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission.
Lordship, I am for the appellant. I am filing the affidavit of service and the statutory deposit of 25,000 has been paid.
This is can one is for condoning the delay.
Lordship, there is a 43 days delay.
ও দুইটা কন্ডো এই 46 তো 45 আগেরটা শুধু কন্ডোনিং দিলেই হলো, বাদবাকি কিছু করা যাবে না, বাদবাকি ডিভিশন বেঞ্চে হবে। Only delay. Yes, 47. 47 you are appearing. Yes. দেখি রেকর্ডটা। Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. The affidavit of service file be kept with the record. Stop. The application for condonation of delay is taken up for consideration. Heard learned advocate for the appellant. Peruse the petition filed. Upon perusing the petition filed and upon hearing the learned advocate, this court is of the view that grounds shown for condoning the delay is sufficient. Stop. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being Can 2 of 2026 is taken up for consideration. Heard learned advocate for the petitioner. Appellant peruse the petition filed. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 2nd September 2025 passed by learned additional district judge, first track, 4th court Alipur, South 24 Parganas in MSC case number 673 of 2022 for a period of 5 weeks. Stop. In the appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General order likhe deben. The service of notice upon the respondents must be effected through the department as well as through personal service. The trial court record be called for and paper books be prepared on arrival of the trial court records. Let this matter appear after 5 weeks.
I'm for the appellant, Your Lordship. I'm
48.
48. I'm filing the affidavit of service and the statutory deposit of 25,000 has been paid.
Can one is condonation of delay. Record an order. Have you filed your affidavit of service? Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. The affidavit of service filed be kept with the record. Stop. The application for condonation of delay is taken up for consideration. Heard learned advocate for the appellant peruse the petition filed. Stop. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. The application for stay being Can 2 of 2026 is taken up for consideration. Stop. As the appellant has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 6 June 2025, passed by learned additional district judge, second court Shuri, Birbhum, in MSCC number 68 of 2013 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Register General ota kore deben. The appellant insurance company shall cause service of notice through the department by filling up necessary requisites as well as through personal service. The trial court records be called for and the paper books be filed on arrival of the trial court records. Let this matter appear after 4 weeks.
My lord, item number 49, my lord, is the appeal of the insurance company, my lord, under the Motor Vehicles Act, my lord. Can one is, my lord, the continuation of delay application. My lord, I have already caused service, and my lord, I have deposited, my lord, 25,000 statutory amount, my lord, and the delay is of 98 days, my lord. Can one.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. The affidavit of service filed be kept with the record. Heard learned advocate for the appellant peruse the petition for condoning the delay. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 19th day of August 2025, passed by learned additional district judge, second court Durgapur, Paschim Bardhaman, in MSC case number 132 of 2017 for a period of 5 weeks. Stop. The appellant shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents through personal service as well as through the department by filling up necessary requisites. Trial court records be called for and paper books be prepared on arrival of the trial court records. Let this matter appear after 4 weeks. A 5 weeks করে দিন।
Lordship, I am for the petitioner manner. There is a section 5 application manner. There is a delay of 167 days. So,
দেখি
last few occasion manner they appeared.
You are appearing for all the respondents.
Respondent number 1 to 5, your lordship.
1 to 5.
Yes, your lordship.
That means 1, 2, and 5.
No, 1, 2, 3, 4,
1 to 5.
Yes, your lordship.
Service is complete upon the other respondents.
Section by the Puno number.
Yes, you have any objection?
No, your lordship.
Yes, record an order. Learned advocate for the petition appellant and learned advocate for respondent number 1, 2, 3, 4, and 5 are present. The application for condonation of delay is taken up for consideration. Heard learned advocates peruse the petition file. Upon perusing the petition, it appears that the petitioner appellants have explained the delay of 167 days in preferring this appeal. Stop. Thus, delay in preferring this appeal is condoned. Stop. Let this matter, condoned. Can one of 2016 stands?
Can 1 of 2016 is a
All
injunction
matter.
and it's the old application number 6009.
Can one of 2016 stands disposed? Let this matter be placed before the Honorable Division Bench having determination in the matter for the purpose of admission.
Yes.
Lordship, in item number 52, I'm for the respondent number 1 and 2. I've been appearing for several times, your lordship, but the opposite party is not, the appellant himself is not appearing in
What
the
is
matter.
this application? Can 1 and can 2?
These two have probably been filed by them, your lordship. I have received no papers, nothing. I have only got the wakalatnama. I've appeared, started appearing, but ever since then, nobody appeared for the appellant.
Recorded too. You are for all the respondents.
Appellant Hasim Mullah and another. The two respondents.
No, you are appearing for three respondents.
I'm appearing for only two respondents, Hasim Mullah and 1 and 2.
The appeal is already admitted.
Lordship, I have seen that on the
Paper books not yet filed.
Not yet filed, Lordship. There is no order at all for paper books to be filed. I've checked all the orders in CIS.
Oh, you are representing Hasim Mullah.
Hasim Mullah and another. The third respondent, I'm not the representative for the third respondent.
1 and 2 you are representing.
1 and 2 I'm representing, Lordship.
Record an order. Learned advocate for respondent number 1 and 2 are present, is present. None appears for the appellants. The matter stands adjourned till 24/6/2026. Under the same heading, learned advocate for the respondent number 1 and 2 is requested to intimate the other side advocate by notice.
Grateful, Lordship. I shall. Much obliged.
You are for?
Respondent, Lordship.
Can one is whose application?
Our application, Lordship.
Your application for?
I was led by Mr. Saptangshu Basu, sir, Your Lordship.
Oh, I think in this matter a report was supposed to be filed.
Yeah, sure, sir.
Anyway, so because state has to be represented,
Yes, Lordship.
I'm keeping it after 3 weeks. Let the state appear. You serve notice. Learned advocate for the respondent is present. None appears for the appellant, state of West Bengal. Let this matter stand adjourned till 1/7/2026. Learned advocate for the respondent is requested to intimate the government pleader by notice.
Grateful.
Yes, not today.
Praying for a Passover.
Okay, pass over.
That I appear for the appellant.
56, my lord, I'm praying for a short Passover.
On behalf of?
On behalf of respondent number 2.
Very good. Lord, on 2nd of August, kindly see the order, 2nd of August 2022. $56. দুটোই একটা সাবস্টিটিউশন একটা সেকশন 5 সাবস্টিটিউশন হচ্ছে ক্যান 3 আর সেকশন 5 হচ্ছে 9072
Yes, you are appearing for?
I'm for the respondent number 2.
So service is complete upon the respondent.
that is the thing, my lord. Most of it has come back, my lord, with the endorsement, my lord, addressee left. And the service upon the, my lord, Jyotirmoy Mondal, দেখো one my lord, it has come back Jyotirmoy Mondal, my lord, as deceased. Substitution served, again deceased, my lord.
Okay, now with regard to one of the respondents, it has come back with the endorsement deceased.
Deceased.
For that you have taken out a substitution application.
No, it is substitution is can 3. It is, my lord, substitution upon the death of appellant number 2.
So it would be better, okay, you take steps with regard to substitution of that deceased person.
Definitely, but provided they have to give the particulars.
That is for respondent number?
1 Gha Jyotirmoy Mondal.
Jyotirmoy
Mondal. 1 Gha.
Yes, I'm granting you 4 weeks time. I can dispense with regard to that other respondents, but for substitution you have to take steps. Yes, you are appearing for respondent 2. So you supply the necessary particulars from your clients to your learned friend.
But actually, my lord, Mr. Mukherjee is appearing, Tanmay Mukherjee.
I'm keeping it after 4 weeks.
But kindly records an order, my lord, they have to substitute.
Yes, record an order. Learned advocate for the appellant and learned advocate for respondent number 2 is present. Service of upon other respondents could not be affected as most of them have left the address, and in the meantime one of the respondent has died. Thus learned advocate is
One
granted.
gho, Jyotirmoy Mondal, one gho, respondent number 1 gho.
That is one
He
of
has
the
expired.
respondent number 1 C.
Gho, GHA.
GHA Gho died. Thus, liberty is granted to learned advocate for the appellant to take necessary steps to substitute the heirs of the deceased respondent. Learned advocate for appearing for respondent number 2 is requested to give necessary particulars to the learned advocate for the appellant so that necessary steps can be taken. Let this matter appear. How much time do you record? 4 or 5 weeks?
My lord, whatever, my lord, when they supply, my lord.
The matter stands adjourned, liberty to mention.
No, 4 weeks, after 4 weeks. Returnable after 4 weeks.
Okay, let this matter appear on 1/7/2026. Just a minute. Not 1/7. 1/7 3 weeks. Okay. 8/7/2026.
Very good. Application আছে
না এটা application for আগের বার interim order extend করে দিয়েছে, ওই দেখুন এই যে এই meeting এর ছিল তারপর তার heading এই application update আছে।
There. 57, my lord.
My lord, 57, I am appearing for the respondent number 1. My lord, application,
And who is from?
can 2.
My lord, kindly see the order dated 23rd February 2026.
Okay.
And one টা তো pending. Copy দাও।
My lord, copy of can 2 has not been served upon me. Can 1 is stay application.
Can 2 is for?
Extension of interim order. My lord had already extended it on 23rd
My
February.
lord, it is ready. My lord, it is ready for hearing. Kindly fix a date for hearing of this application, hearing of the appeal, my lord.
Because of the stay application and my lord.
My lord, this is section 4, section 44 of the Transfer of Property Act. Suit for Transfer of Property Act. And the suit was dismissed. My lord, I am appealing for the appeal plaintiff.
In the application for stay, are the affidavits complete?
But they have not filed affidavit.
I have not given any affidavit, my lord. And stay application extension is not application for extension has not been served upon me. My lord, it may be extended, but my lord, kindly fix a date for hearing, my lord. Hearing of the appeal paper book is ready and it is served upon me.
Hearing, my lord, so
paper
long.
book is ready, my lord.
Hearing cannot
Kindly
be.
fix a my lord. Kindly fix a date for hearing of the appeal.
By confirming
Okay.
Appeal, my lord. My lord, kindly. My lord, kindly.
Let me fix a date for hearing of the appeal, and in the meantime, let me extend the interim order for a certain
In
period.
the meantime, my lord, date fix and let it be extended.
Okay,
It
I'm
may be extended.
interim order. I'm fixing the date for hearing of the appeal.
Yes, my lord. Yes, my lord.
Yet, my lord, interim order pending appeal hearing, my lord, cannot go simultaneously unless interim order, my lord, interlocutory applications are disposed of, matter cannot be fixed for hearing.
No, question is
Cannot be fixed for so long interlocutory
when the
application.
matter is ready for hearing, where is the bar to hear out the matter?
Yes.
So long interlocutory applications are pending, I do not know, my lord, whether it can be fixed for final
That
hearing.
is the discretionary power to extend the interim order.
My lord has exercised that discretion already.
What do you want?
May be extended. My lord, it may be extended. My lord, kindly fix the date for hearing of the appeal. Hearing of the appeal. I am offering, my lord. Date of hearing. My lord, fix any date.
can 1 টা হবে কি করে? Can 2 টাতে?
Can 2 টাই pending দেখাচ্ছে। 1 is disposed of.
Yes, record an order. Learned advocates for the parties are present. Let this application
একটা কপি দিয়ে
Can 1 of 2025 appear for hearing
ফাইলিং স্লিপ আছে তো।
on 17/6/2026.
17.
Will you use any affidavit to the application for stay? Do you want to
My
use
lord,
an?
no, I don't. I don't want. Let it be fixed for hearing.
No, I'm fixing the application 17/6.
Or application
Yes, 17/6 next Wednesday.
Very good.
next Wednesday.
The interim order granted earlier stands extended for a period of 3 weeks or till further orders, whichever is earlier.
And it will it will come on next Wednesday, my
Yes,
lord,
next
17.
17th.
এটা কি জেরক্স করে দেবো একটা কপি দেবো?
Grateful, my lord.
Acha. The copy of the application Can 1 of 2026 be treated as the original Can application.
Can 2.
Can 2 application.
But I have to make a photocopy. I do not have a copy. I'll give a photo.
The photocopy be kept with the record.
My lord, let the copy be served upon me, my lord. Let the application be served upon me.
Copy of the both copy of both the application be served upon the learned advocate for the respondent.
জেরক্স করে তো দিয়ে দেবো, তুমি তো অপোজিশন দেবে তো আমায় লিখতে হবে তো। হ্যাঁ তো দিয়ে যাবো, বললে আমি জেরক্স করে দিয়ে দেবো, অসুবিধা কি আছে? হ্যাঁ ঠিক আছে, আমি জেরক্স
Yes, give one copy in the course of the
yes, but I do not have an extra copy.
Yes.
এটা ফটোকপি করে দিয়ে যাবো, বন্ডে করে।
এরকম যে খরচ থাকতে অফিসার দুখান নাই।
কি ব্যাপারে? Great, my lord, in this matter, my lord, I am appearing for the appellant petitioner.
Yes. Can 1.
The application, the second appeal, my lord, admitted for the defendant tenant. Eviction degree were passed. Against that, my lord, the second appeal has been filed and that has been admitted on the substantial question of law. This is an application for injunction restraining the defendant plaintiff from putting the degree into execution. So I am praying for stay of the execution proceedings because after filing of this application, we came to know that execution has been filed.
So copy served of Can.
No, this is the first time, my lord.
When is the next date fixed before the trial court?
July. My lord, in the month of July.
So let it appear next week. Wednesday, you serve a copy.
As a lordship, as a lordship.
Learned advocate for the appellant petitioner is present. Let copy of this application Can 1 of 2021 be served upon the respondents of entered appearance.
Here, my lord, we did not been informed regarding any appearance of the respondent. We have deposited the postal cost and other things as per the direction of the Honorable Division Bench.
You serve it upon the respondents. Let this matter appear on 24/6/2026. Anyway, the matter is in the month of July.
Yes, requisite files, Columnar file or
whatever it is, you serve copy of this application. I'm keeping it after 2 weeks. 24/6/2026 under the same heading.
If my lord abandon caution, if they make put up, we can pray for an adjournment with the executing court. I am not saying for stay.
No, matter is in the month of July.
Yes, now if there is put up, my lord knows very well, my lord.
You mention the matter, I shall consider that.
Only that thing, my lord, so I can pray for an adjournment there. There is a pending or
as the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Executing court, my lord.
Trial court stroke executing court, which may be considered.
59 Lordship.
For the opposite parties.
I am applying the appellant Lordship.
My lord, this is the copy of my affidavit in opposition in connection with CAN 2 stay application.
Let me see.
50. This is the 59. Can 2. Other can are already disposed of. Can 2 Lordship application for stay of the execution proceeding. Appeal was admitted by formulating the substantial question of law on 15th January 2025 and also granted order of stay of the execution proceeding for limited
Let me see
period.
the order of admission.
15th January 2025 Lordship.
কেটে একটা কপি দিয়ে দাও দাদা একটু ওটা কেটে দাও
অর্ডারের কপি আছে
হ্যাঁ কেটে একটা কপি দিয়ে দাও
Got it Lordship?
দাদা এটা জজকে দিয়ে দাও
It was admitted by two substantial question law framed and also taken up can 2 stay application. Next page Lordship.
Can 2, can 3.
Can 2.
Can 2.
Can 2. Can 3 already Lordship disposed of earlier.
Can 2 is only with regard to stay.
Can 2 is regards of stay of the execution proceeding.
He is already granted.
Already granted and also Lordship also it was extended on 22nd April 2026 for 4 weeks.
Now let me see his opposition.
Lordship.
Okay, let me see the order of admission first.
Lordship, may I be permitted to hand over my copy?
Yes, give it.
It is your 17.
So here your learned friend has filed affidavit in opposition.
Yes.
Regarding affidavit in reply, have you filed that?
No necessarily only saying the factual aspect in the opposition and only on.
Sir, ready?
Yes, yes.
Have you filed the paper books?
No paper possibly LCR. I do not know whether LCR was received. Yes, then within 2 weeks I filed the paper book. In the opposition only stated the factual matters and paragraph 4A they are saying that
It's not a case of any eviction, only demolition.
Demolition. Suit filed by the plaintiff for declaration that the defendant constructed the house by violating and or without sanction the plan without giving any mandatory open space so that obstruction the natural air and light and demolition of the said illegal building of the defendant and mandatory injunction. This is the suit.
Yes, record an order. Learned advocates for the parties are present. The affidavit in opposition filed by the respondents. You are for all the respondents. Be kept with the record. As the trial court records have come, let the paper books be filed within 2 weeks. Let this matter appear on 1/7. Let this matter appear on 29/6/2026 under the heading to be mentioned. The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Loss. কপিটা বের করে রাখতে হবে।
Item number 60 for the respondent, my
60.
60, my lord. And for the respondent, my lord.
And for the petitioner, your lordship. I'm praying for only not today, your lordship.
So not today.
This is my application. This is for
I am for the respondent number 1, 2, 3.
addition of parties and the expunge the name of the sole appellant who died
Let me see.
before his,
You are representing the heirs of the sole appellant.
yes. Years and also what happened was in this matter, after this appeal was admitted, then thereafter, during his lifetime, during the pendency of the appeal, he executed 2 deeds. One is his brother, his son, and his brother's sons. 2 deeds. They given the entire his land to them. Now, my lord, that sole appellant died. Now, 3 and 4 died, and my lord filed an addition of parties and also expunged the name of the sole appellant. And they should be treated as appellant.
You are for all the respondents.
1, 2, 3, my lord.
They are the main contestants. Right?
Dependent respondent, my lord. What happened, my lord? Whole appellant died on March 29, 2022. My lord, in the meantime, my lord, before filing of the application, my humble submission, the second appeal has been abated. My lord, no substitution application has been filed, my lord, till date.
So did you, no, question is, here you see, here that means he is relying on the assignment. On this assignment, by virtue of that assignment, he has come to the picture. Okay. So under order 22, rule 10.
Well,
Well, in the meantime, it has been
So have you prayed that abatement if any be set aside?
no application is there. My lord, his
Just a minute.
daughter is also there, my lord.
Question of daughter does not arise because he has already assigned the entire property to their son and the nephew during his lifetime. That is the case.
না না সুটটা কিসের সুট ছিল সুট
Suit for declaration of title permanent. তোমরা বিক্রি করে দিলে
ভুলে গেছি কত ভুলেছি জল খেয়ে গেছি উপরে উপরে দেখলাম সকালে আমরা মামলা দেখে দৌড়ে এলাম
So he died in 2022. Why have you come after so many years?
My lord,
4 years, I think.
not 4 years, 23. 2023 I have filed.
When did you come to know about this death?
7 or 8.
No, no. Where is,
Son and nephew, my lord.
You have not made any prayer that the abatement is be set aside.
Regarding abatement, my lord, there is a mistake,
Yes.
my lord. Abatement, my lord, yes.
Setting asset abandonment, then this application will come, my lord.
So how
Okay,
can
what
I,
application it can be
in
done?
a dead case, how can the court allow you to enter? The case is dead. You have not made any prayer.
So, my lord, allow me to, my lord, amend this or allow me to another application for amendment. Because only 8 months back, I think, my lord, there is a delay of.
See, how can I
But
permit
that's
you
right,
to
that's
enter
right.
into a dead case?
I'm not arguing in that point.
Yes, record an order. Learned advocates for the parties are present. The applicant has taken out the application CAN 3 of 2023 to be for deleting the name of the appellant, Bonkim Bihari Mahato, and to implead himself being the assignee of the said appellant with regard to the suit property. The applicant has further taken out an application under Order 1, Rule 10(2) of the Code of Civil Procedure for addition of party in this appeal, SA 11 of 2023. Heard learned advocates for the parties. Mr. Dash, learned advocate for the respondent, submit that without the abatement being set aside, the applicant cannot be impleaded in a suit which is already abated. Stop. Learned advocate appearing for the applicant prays for necessary leave to make rectification in the prayers of both the petition. Thus, leave is granted to the learned advocate for the applicant to make necessary rectification and addition in the prayer of both CAN 3 of 2023 and CAN 4 of 2023. Upon considering the provisions of Order 1, Rule 10(2) of the Code of Civil Procedure and the provisions contained in Order 22, Rule 10 of the said code, this court is of the view that these applications should be allowed. Thus, CAN 3 of 2023 and CAN 4 of 2023 stands allowed. The name of the sole appellant, Bonkim Bihari Mahato, be deleted from the cause title, and the name of the applicants be impleaded in his place and stead. The department is directed to carry out the amendment within 2 weeks. Liberty to mention. So make necessary rectification in your prayer.
And one thing, my lord, the my paper book has not been concluded.
Okay, let it come after amendment after 2 weeks.
My amendment petition shall file for
Yes. So I have directed the department to carry out the amendment within 2 weeks. Thereafter, you mention and make the necessary rectification in your prayer.
I am for the appellant applicant, my lord. Lord, CAN 1 is for section 5, my lord. On 9th February 2026, my lord, one respondent number 1A to 1I appeared. They sought for, my lord, adjournment on the ground that they want to use an opposition. But, my lord, till date, no opposition filed, nor today they are appearing. And service was effected upon all the respondents. My lord, delay is of 262 days. And, my lord, main reason is lockdown, because the judgment and decree passed on 7.
Anyway, let it be a last chance. If they don't file, come, I shall take it up in their absence. Yes, record an order.
Next week, fix a date because admission.
Learned
period
advocates
will
for the appellant is present, none appears for the respondent. In terms of earlier order, no affidavit in opposition is used to the application Can 1 of 2023. Thus, liberty is granted to the respondents as a last chance to file affidavit in opposition, failing which the matter will be taken up without affidavits and in the absence of the respondents. Let this matter appear on 17/6/2026 under the same heading.
Great.
I am appearing for the respondent.
And I am appearing for the appellant, my lord. This is coming under the heading of extension. My lord, last occasion, my lord, it was.
But the matter was appearing under as
Right.
hearing matter. If your lordship sees the earlier orders, thereafter in the meantime,
31st March 2026. It was last
that
extended.
was the last order, my lord. The interim order expired in April.
The matter is ready for hearing.
Yes, it was appearing as hearing for hearing.
So let it appear for hearing.
My lord, that is my prayer, my lord. Matter was already.
Kindly extend the.
If your lordship sees, my lord, the records, my lord, it was already appearing as hearing. So, my lord, kindly do not, my lord, keep it as under the heading application.
Achha. Record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books already filed, let this matter appear for hearing. দেখুন তো কত 22 কি 23 কবে ইয়ে করা যায়?
দাড়িটা দিন।
2 PM এর দিকে।
Lordship, kindly make it.
যে কোনো ডেটে 2 PM.
2 PM.
Huh? On 24/6/2026 at 2 PM.
Lordship, much obliged.
Interim order has expired.
Yes.
Is there any execution proceeding?
Yes, yes.
Yes, yes, ma'am.
The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Deeply obliged.
Yes, next.
Item number 64, record of Mohammad Mahmood.
You are for?
Record of Mohammad Mahmood. Serious is ill, so I praying from not this week.
Okay, not this week.
I appear for the respondent. In this matter, my lord, kindly see the office report dated 19/12/2024. Then there was a direction for the correction of the lower court order passed by this learned trial judge. And thereafter, my lord, since my lord, the appellant is enjoying the interim order of injunction, I filed an application for call for the file the paper book. Paper book they have not been filed. And call for the LCR has not been, my lord, reached to the department. Can see I have been filed.
No, whether special messenger cost was deposited.
Nothing has been deposited. There is a
দেখুন তো trial court records এসছে।
ACD. It has not been called for, and along with my lord, the office, so kindly see the office report, last office 19/12, the office report.
Office report টা দেখেন।
So কিছুই নেই, only injunction. They are enjoying the order of injunction.
হ্যাঁ কি ট্রায়াল কোর্ট রেকর্ডস আর লাস্ট ইয়েটা কি আছে ডিপার্টমেন্ট থেকে কি নোট দিয়ে পুট আপ করেছে ইউ আর ফর অল দ্য রেসপন্ডেন্টস
I am all the respondents. এই রিপোর্টটা দেখেন।
কি নোট দিয়েছে ওটা হ্যাঁ
Effective আছে, মানে lower court record is effective order.
Oh, the appellant did not turn up due to the department. Anyway, let them get one more chance. Yes, record an order. Learned advocate for the respondent is present. None appears for the appellant. Stop. It appears from the report of the department that in spite of the direction to the learned advocate for the appellant, the learned advocate has not turned up to the department to remove the defect. Number 2, as regards valuation of stamp in the memo of appeal. In the facts and circumstances, the matter stands adjourned till 1/7/2026. Learned advocate for the respondent is requested to intimate the other side advocate by notice for taking necessary steps in terms of earlier direction.
Date to packet appear on
1/7.
1/7. Very good.
হয়ে যাক 12টারটা আগে 10:30 ফিক্স ম্যাটারটা 10:30টারটা আগে নেবো, তারপর 12টারটা নেবো। না না, এটা হয়ে যাক অ্যাপ্লিকেশন এক্সস্ট হয়ে যাক, নইলে অ্যাপ্লিকেশন হয়ে যাবে বা মোটামুটি 12টা অব্দি অন্তত এটা নেওয়া যাক। 12টা 10-15-তে ডেকে দেবেন 10:30টারটা।
Yes, Your Lordship. We are appearing on behalf of the respondent petitioner, Your Lordship.
You are?
I am from for appellant.
So whose application is this? Can one?
Our application
For?
for repair of a door and its frame. Your Lordship, this is the affidavit in reply.
This is your affidavit in reply.
Yes, Your Lordship, this is the affidavit in reply. We have already served the same on 13th March upon the other side.
No, what is the suit for?
Suit for eviction, Your Lordship, under Section 6 of the West Bengal Premises Tenancy Act.
So during the pendency of this appeal, you want to carry out the major?
Major, not major. Your Lordship, one door, Your Lordship, and its frame, Your Lordship.
Anyway, let me see the opposition.
Yes.
Hey, opposition to the nectar. A reply to.
Your Honor, I am praying for not this week.
Achha, record an order on the prayer of learned advocate for the respondents. The matter stands adjourned till.
Your Lordship, one indulgence, Your Lordship, if Your Lordship kindly be pleased to fix a date.
Yes, 17. Next Wednesday, 17/6/2026, under the same heading. Let the affidavit in reply file be kept with the record. So come ready on the next day.
Yes, appellant.
No, you are?
Yes, Your Honor, I am appellant.
Appellant.
Please
Oh, you are the respondent. Respondent tenant.
Respondent tenant.
Okay.
I'm for the appellant petitioner led by Mr. Banerjee, my lord.
I am for the
There was a
respondent, my lord.
direction.
Yes. What was the direction? Let me see that.
Yes,
My
kindly
lord was
seize the last order, my lord.
appoint Mr. Dotto as Basu as special officer, and to submit his report, my lord, kindly direct him to supply a copy of the report to
No,
us
my lord,
also.
what has happened is he has not been able to conduct the inspection, and my client takes full responsibility. There was some miscommunication.
Let
He
me see
was
the
not
report,
there.
okay?
Yes, my lord.
Is the report is already circulated?
No, I have.
But I have a humble prayer. But the remuneration of the special officer has not yet been cleared from side of my client. I am praying kindly keep it after a week, Milord, so that Milord, it can be.
So inspection has not yet been carried out.
It has taken
To the predicaments he has expressed in his report.
No, no, my lord, he had been to there.
No, he has stated all this.
Yes, and kindly peruse the report, my lord. My lord, everything will be clear. The inmates did not allow him to enter into the premises.
No, they were not there.
And my
Medical
lord,
emergency, they had to leave.
his other family members were there. They were found taking photograph of the special officer from the first floor. How can they go to the first floor? They were the tenants in respect of the ground floor only.
These are not submissions from the bar, but my client was
kindly peruse
due
whether
to a medical emergency. he could
whatever
not,
I am
Milord,
submitting, whether these things are reflected in the special officer's report or not. If it is reflected in the special officer's report, then it is a matter of record, not a submission from the.
I was praying for 7 days time so that Milord, his remuneration can be cleared.
Milord,
my client can't have any objection to that.
Question is, inspection could not be carried out in the suit room. What was the order to carry out the necessary inspection of the suit room? And other particulars were there. So that could not be carried out as because that was under lock and key.
He was on a medical emergency. He had left. He was not.
Okay, record an order.
Kindly give me some time.
Learned advocates for the parties and the learned special officer is present. The report filed by the special officer is kept with the record. Upon perusal of the report, it appears that the suit room was under lock and key, for which the special officer could not carry out the inspection. Mr. Banerjee submits that as because his client was out of station, for medical reasons, and an opportunity be granted so that the inspection is carried out. Stop. In the facts and circumstances, the matter stands adjourned till 1/7/2026. The learned special officer in the meantime shall, upon prior intimation to both parties, carry out the inspection work as per the earlier direction dated 21/4/2026. The order dated 21/4/2026 is unaltered. Stop. The remuneration which is not cleared from the side of the appellant.
I'm the appellant.
From the appellant be cleared forthwith.
We shall. And Milord, the interim order had expired in the meantime.
No, Milord, we are proposing, Milord, because
Achha,
Milord, kindly appreciate.
the cost of the inspection work shall also be borne by the parties equally.
No, Milord, I do humbly request you.
Suppose there are certain transport costs.
No,
they are taking.
His remuneration, he had been.
Remuneration is another thing, and cost of inspection is another thing. Whatever are the transport and other incidental costs, both of you share it. Okay, that is usually done in all cases.
That yes.
Achha, another question. When did the interim order expire?
During vacation, Milord.
The interim order.
Kindly record, Milord.
Although it is opposed by the learned advocate appearing for the respondent with regard to the extension of interim order, but in the interest of justice, the interim order stands extended.
They have not paid a
for a
single
period of
has rent for last
for a period.
years.
Anyway, let the report come for a period of 4 weeks or till further orders, whichever is earlier.
I'm not the date of next
Yes,
returnable date.
17.
17th of June.
17.
1st of July. 1st of July.
In the meantime, let it be carried out.
I'm ready. अपनी ये द्वितीय दिन
For the applicant. My lord, the last occasion, my lord, that is 10/4/2026, my lord was pleased to send this matter before the mediator, my lord. But unfortunately, mediation was failed, my lord. Kindly fix one date for the
So
hearing.
parties appeared before the mediator.
Yes, my lord, both the sides.
I'm for the respondent.
So let this appeal be fixed.
The respondent not appeared physically, my lord. They appeared through their advocate.
So probably Justice Sengupta was the mediator.
Yes, my lord, referred that, but they have said one other mediator, that is Mr.
Let me see the order.
This is 10/4/2026. For that, my lord. On 17/2/2026, my lord has referred Justice Kulanjuti Sengupta, my lord, as a mediator, my lord. The second paragraph of this 17/2/2026
Yes.
order. After that, on 10/4/2026, my lord, in between, they have not fixed any date for the mediation.
No,
For
has the mediator fixed another date or the mediation proceedings failed? Let me see the report.
mediation held, my lord, but failed, my lord.
Just a minute. Yes, record an order. Learned advocates for the parties are present. As this matter was earlier sent for mediation and the mediation proceedings have failed, let this matter appear for further hearing on দেখুন তো 22 তারিখ 18 কিংবা 22 ইয়ে আছে কিনা
That can it be on after 8th of July?
It will be too long. You are for the
Yes, my
respondent.
lord, we are
It will be
suffering,
too
my lord.
long. Enough time you got.
As your lordship pleases.
Huh? Okay. 23/6/2026 at 2 p.m.
Grateful, my lord. My lord, another thing is this, there was an interim order passed by lordship, my lord. That was expired yesterday
Yes,
only,
the
my lord.
interim order passed earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Great. ওনাকে দিলাম
Well, pursuant to lordship's action, I am filing the affidavit in opposition.
My lord, I am for the applicant, my lord, Mr. Pathupotham Roy is leading me. But my lord, we could not file the reply, my lord, because my client was out of station due to some medical emergency.
You are for the appellant?
My lord, for the applicant, my lord.
Enjoying an interim order. I have filed my opposition. I have served the copies, my lord.
Acha, record an order. Learned advocates for the parties are present. Let the affidavit in opposition file to Can 1.
Can 1,
Can 1. Can 1 and Can 2.
Can 1 of 2024 and Can 2 of 2024. File to Can 1 of 2024 and Can 2 of 2024 be kept with the record. Let this matter
Copy served, my lord.
Copy served. Let this matter appear on 17/6/2026. The reply may be filed in the meantime.
Grateful to lordship.
So come ready on the next day.
And my lord, there was an interim order now that has expired, my lord, during the
The
vacation.
interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier.
Kindly record a formal objection to that, my lord, to the interim.
It's earlier it was extended
Yes, yes.
also.
My lord, I am appearing on behalf of the other respondents.
Yes, give your names.
Grateful to lordship.
Grateful.
Lordship, the advocate of the petitioner is not present today. I am praying for only for not today.
Okay, I'm making it not this week.
Not today only, Lordship.
Okay, not today.
Lord, I beg to appear on behalf of the respondent applicant.
My lord, in this matter, my lord, Mr. Shotto Mukherjee is appearing on behalf of the appellant. My lord, upon instruction.
This matter is to be taken up. Can 4.
Can 4. This is, my lord, innocuous prayer, my lord, for preparation of paper book. I, my lord, suppose the other side is not.
So,
my lord.
Okay, so let a date be fixed for hearing of this matter. Paper books be filed in the meantime. Yes, learned advocates for the. You are for all the respondents.
My lord, Mr. Shotto Mukherjee is appearing. I am appearing on instruction, my lord. He is engaged in
Learned
court file.
advocates for the parties are present. Liberty is granted to the learned advocate for the appellant.
For respondent.
Oh,
1 to
advocate.
7.
Respondent number 1 to 7 to prepare the informal paper books within a period of 4 weeks. Trial court records have come.
Record to come. Yes, yes.
Let this matter. Let the paper books be filed and served upon the opposite party. Oh, trial court records
নেই।
নেই? Otherwise, how will you prepare that?
No, as per Milord, the record there, the in department the record has come. TCR has come.
আচ্ছা,
না, এটা তো
অর্ডারটা করে দিয়ে আর কি, অর্ডারটা করে দিয়ে লেট দি, কি লিখলাম বলুন তো একটু?
Given to the learned advocate for the respondent number one and to prepare the informal paper book within a period of 4 weeks.
Within a period of 4 weeks. And be served upon the opposite party. Stop. The file be sent down to the department to enable the learned advocate to take necessary steps. Liberty to mention after 4 weeks.
4 weeks. Paper book এত second appeal paper book basically. Great. And the can 4 is disposed of, Milord.
Okay, the can 4 of 2026 is disposed.
Great.
Can 4. Paper books से prayer. 72, yes, not today.
73, my lord, I am for the petition.
Respondent plaintiff.
Lord, appeal was admitted before by the division. May
Can 1.
bolo.
Can 1 for?
And one for stay, my lord.
My lord, interim order granted by the division bench.
No. Because can was not filed, that is why interim order was not granted.
You want to use opposition to can 1?
Yes, my lord. This is the opposition, my lord. My lord, before my learned friend enters into the matter, I would indicate some things to my lord. My lord, kindly comes to the page number 10.
Chain of opposition.
Opposition, of my opposition.
Yes. Page
My lord,
10.
10 of my opposition.
Yes.
My lord, before my learned friend prepared this appeal, I have filed the caveat before this honorable court. But my lord, now, my lord, am I with your
Yes.
lordship?
Yes.
My lord, this is the caveat, my lord,
Yes.
page 10. Now, my lord comes to the page number 13 of my opposition. 13, my lord, at the bottom, column 5.
Yes.
My lord, this is the title suit number 1287 of 2018. This is my title suit number. This is the title suit, original title suit number, my lord.
Now you see one thing regarding admission of appeal, caveator has no audience.
My lord, this is
Right
my
of
lord,
audience.
Yes, my lord. My lord, this is how the embargo has been bypassed.
Question you see, you may be a caveator, but prior to passing an order of stay, you are to be heard. But for the purpose of admission, caveator is not required to be heard. This is the rule.
But my lord, the actual information has been altered.
No, the question is when the matter was admitted, you were not present.
No, my lord.
Anyway,
No, order 41 is
this stay application, the order of stay will be considered upon hearing you.
Yes, my lord, but my lord, the information has been altered. I didn't
No,
get
what was the
proper
information?
thing.
Let me see.
Yes, my lord. My lord now comes to the page number 18 of my opposition.
No, let me see the record, okay, regarding any intimation of caveat was given or not.
Yes, my lord.
What was the endorsement made? Memo of appeal ta dekhiye.
And regarding memo of appeal, my lord, we have sent a letter to the learned other side, but any memo has not been served upon us.
Anyway,
Dada, Judge Sahib ke take.
Entire thing will be served, not only memo, entire paper book will have to be served upon you.
Till date, even after the
Entire thing.
communication.
Only you have received this application for stay. Now only for the purpose
Since
of.
they have no right to audience in Order 41, Rule 11, that is why I have not served.
Yeah. application for state দিন যেখানে ওই যে no No, you appellant has admitted that caveat already received in your application.
My lord.
In this application, okay.
And I have served. Without serving that, I have also intimated that without
No, before
serving.
admission, we have not served.
No, before admission, I should.
Only in
will
case of
serve.
yes, in after admission, had the application for stay been taken up, definitely she was required to be served. Yes, now this application for stay has been heard out. You file your opposition, you file your reply.
No, today I have received. I will file within a week.
Yes, record an order. Learned advocates for the parties are present. Let affidavit in opposition filed to Can 1 of 2025 be kept with the record. Let reply be filed on or before 17/6/2026. Let this matter appear on 17/6/2026.
My lord, can it be 18? Can it be 18th?
Applications are usually taken up on this 17.
And a stay may be granted till 18, my lord.
How, my lord?
Okay, then 24th. 24/6/2026. When is the next date before the trial court?
I believe, my lord, 26th.
Yes.
I believe 26th.
As the matter is sub judice before this courts, parties are permitted to seek necessary adjournment before learned trial court, which may be considered.
Grateful.
My lord, it is till 24th, right?
No, no. No, I have not passed any interim order, but I have permitted the parties to seek adjournment before trial court. If it is taken up prior to 24th, on 24th the matter will be.
My lord, it will be
Very well.
26th.
Let the matter be taken up on 24th.
Then, my lord, kindly write another line that after 24th.
No question. If the matter is not taken up, necessary direction can be issued, but just wait for 24th.
Grateful, my lord.
My lord.
Honored, I am for the petitioner. Appellant. This is an application for appellant. Okay.
Lord, in this matter, my lord, before taking my lord, your lordship passed the order in the earlier matter. This type of matter, my lord, the lower court influence and my lord, to some extent.
Very well, some justice has to be done. Okay. Now, what is this matter about?
It
My lord,
is
this is
matter, my lord.
application for condonation of delay.
Where is
And
that
my lord,
application? Let me take a,
for
let me see.
My lord?
Where is that application?
Yes, my lord, it is scan 2 of 2026. My lord, I am also filing a supplementary affidavit.
My lord, it is the stage of execution, my lord.
No, can 2 is for condonation of delay.
Condonation of delay filed earlier by stating inter alia, there is a 8 months delay. Thereafter supplementary affidavit filed, there is a 552 days delay.
552
days delay in the
My lord,
supplementary.
everything has been, बोला नहीं? My lord, if your lordships kindly take up my application for condonation of delay.
Okay, just.
My lord, kindly come to.
Have you filed your opposition to this?
No file. My humble submission before your lordship, whatever the application adjudicated by this honorable court after filing opposition or before filing opposition, but my lord, kindly, my lord, passed an order, earlier occasion, your lordship passed an order, seek adjournment and may be considered by the.
Yes, that can be done. There is no part. That can be done.
But by this order, the lower court, it is treated as a interim order.
Very well. You see, in the interest of justice, some adjournment can be granted by the trial court.
Second appeal, no admission, no stay order.
Very well. You see, then if necessary, then some interim stay has to be granted.
In the middle,
Yes.
in the stage of condonation of
In
delay
exceptional
application, if your lordship allowed the condonation of delay.
No.
If your lordship, for the sake of argument, allowed. In that case, my lord, admission will be heard by the honorable division bench.
Very well.
But without.
But during the hearing of this application, if some irreparable loss causes,
your lordship dispose of application.
You see, always courts are always empowered
Yes,
to
my lord,
give that interim. Courts are always empowered to
Yes,
give
my lord.
interim protection.
Then, my lord, your lordship earlier occasion, he filed an application for condonation of delay by stating interior that 8 months delay.
Yes.
Though there is no cogent reason for
the question is now let this matter be taken up where any execution case is pending.
Yes, my lord.
Yes, my lord, it is partition suit arising out of a partition.
Execution case, my lord, holding up due to order passed by your lordship may be considered adjournment. No, this is not, my lord. My question is the execution is a separate proceeding. Execution proceeding will not be stopped by this order.
Other than if it is executed, it will be meaningless. See, 151 power is given
in the stage of
in the interest of justice to prevent the abuse of the process of court.
At the stage of for allowing condonation of delay.
That is why section 151 is conferred upon the courts. Otherwise, irreparable loss will take place. The matter will be kept pending, and in the meantime, the parties will be thrown out.
No, my lord. This is not, my lord. Your lordship, not to pass any order in connection of this order, except, my lord, regarding condonation of delay.
Question is, you see,
enter proceeding.
Otherwise, you see, due to the delay of this pending, suppose parties seek adjournment, there is a delay of this matter. Now the question is, if the matter is executed, then it will become infructuous.
There is no question of any stay application, my lord. If it at the time of, my lord, hearing of the condonation of delay, court stayed the order, enter proceedings.
Yes, that power, yes, in different matters it is done. Okay, court has always that inherent. Court has inherent power under 151.
So either passed interim order that stop enter proceedings.
Okay. Very well.
Your lordship passed order that maybe file an application for adjournment and court will consider. But if your lordship High Court directed will consider, the lower court cannot.
Very well. It is the discretion of the lower court.
Discretion of the lower court.
Discretion of the lower court. In the interest of justice, the court can adjourn. No bar.
Then suit failed, appeal failed. In the second appeal, not admission, no stay.
Very well.
At the time of hearing of condonation of delay,
very well. They have not yet started the submission. All at a sudden, why are you obstructing? Let them.
Passed earlier order. That's
very well. You see, if you are aggrieved by the order, you say that. Let me hear him.
Yes.
Some interim protection should be given, otherwise
But it
entire
should
thing will be
interim
meaningless.
Protection at the time of hearing of the my lord, application for stay.
Very well,
Not
very well. You see,
application in the condonation of delay.
The inherent power is always vested in the court.
That is the
Yes,
vested in
what
the
is the
My lord, page 6, paragraph 20, my lord, the title appeal was dismissed. It was not on merit, on technical point. My lord, if your lordship kindly come to page 6, paragraph 16, that on April 19, 2024, your petitioners filed title appeal number 30 of 2024, challenging the trial court's judgment without accompanied with the
No, just a minute. Which paragraph?
Paragraph 16, page 6.
Yes.
Page 6, paragraph 16. My lord, I filed the appeal, title appeal, challenging the trial court's decree, my lord, without accompanied with the certified copy of the judgment and decree. It was, my lord, 19th of April. On next, my lord, the title appeal, I filed an application praying to file certified copy of the impugned judgment.
6 of can
page 6 of can 2.
Can to not supply.
Key can to not
supply. 6 number, it's paragraph 8.
Hmm.
Not supplementary.
No, I am reading this, I am considering this can too.
Can to mean it is a previously, thereafter supplementary.
No, my lord,
supplementary.
previous application is can do.
Yes.
My lord, in the can do, but only quantum was wrongly written. Therefore, not I have filed the supplementary appeal.
So you are now addressing on can too.
Can 2, my lord, page 6, paragraph 16, I have stated that I filed the appeal without accompanied with the certified copy of the judgment decree. Paragraph 17, I filed an application, my lord, to file the judgment, certified copy of the judgment and decree. My lord, next date, my lord, was fixed, May 10, 2024, filing certified copy. My lord, paragraph 19, after getting the certified copy, I filed it. My lord, on 10th of May, paragraph 20, my lord, appeal has been dismissed by holding that the petitioner has filed the appeal without certified copy of the judgment. For this reason, my lord, the appeal has been dismissed without going into the merit. Although I have, previous to that, my lord, I have filed the certified copy. I have filed the certified copy on, my lord, April 24, 2024. In May 10, appeal has been dismissed for non-filing of the certified copy. I have filed it within time.
Now the question here is, what is your ground for condoning the delay of this?
Now, my lord, kindly come. Then, my lord, after the dismissal of the title appeal, now, my lord, kindly come to paragraph 21.
Yes.
As per advice of Mr. Kinkor Bose and Alaya Kwarisi, learned advocate, on August 6, 2024, that is within 90 days, your revision petition was filed. It was, my lord, as per erroneous advice. As per erroneous advice, a civil revision was filed challenging the judgment, dismissing the title appeal. My lord, that civil revision, my lord, I have annexed the status report. It is at page 11. The filing of civil revision.
11.
Page 11, last page, man.
No, you have filed civil revision against which order?
That is the, my lord, difficulty as per erroneous advice of the learned.
No, page 11, no. Your title appeal was dismissed on May 10, 2024.
My lord.
Okay. Against that, you have filed a
civil revision before this honorable court.
On August 6, 2024.
That is within time, within 90 days.
Okay, civil revision.
That status report is, my lord, at page 11.
This matter was disposed when?
No, it is still pending. It is still pending. My lord, the revision petition was filed by other advocates, not by me. My lord, when the client came to me, I advised him, my lord, that appeal is required to be filed, not the civil revision. Because dismissal of title appeal is judgment and decree. A revision cannot be filed. For this reason, my lord, the delay is there.
And what is your supplementary affidavit?
My lord, supplementary affidavit, my lord, only quantum, relating to quantum. My lord, I have explained day by day. My lord, in the can 2, I have stated that the delay is about at page
8 months.
Page 9, paragraph 33, I have stated it is 8 months. Delay is of 8 months. It is, my lord, by mistake. Quantum, 8 months is mistake. Therefore, my lord, I have filed the supplementary affidavit. At page 2, paragraph 4, I have stated The period has been explained. But the quantum, whether it is 8 months or 552, that is the typographical mistake.
Quantum means regarding
delay in filing the appeal. I have
When did you
explained.
file this? No. When did you prefer this appeal then?
I have filed this appeal on my lord, February 11, 2026, paragraph 28, I have stated. Page 8, paragraph 28. Page 8, paragraph 28. February 11, 2026. It is about 2 years.
2 years delay.
Some less than 2 years. But my lord, by mistake, I have stated that it is 8 months. It was my lord, typographical mistake. Therefore, I have filed the supplementary affidavit. That the my lord, paragraph 4 of the supplementary, kindly see, that delay in filing the appeal is about 552. And such delay has been properly explained in the application for condonation of delay. But inadvertently and by bona fide mistake in such application, quantum of delay has been wrongly written as 8 months. It is not that I have not explained the entire period. I have explained entire
almost
period.
2 years.
My lord, I have explained the entire period. I have stated all the facts I have stated.
Yes, what do you say?
Not entire allegation against the one advocate was due to Milord misinstructed, misinformation, Milord, I filed this case. This is not a justified ground for condonation of delay, Milord. Today, if not his client not taking advice from my learned advocate, then another wrong will be done. But another explanation that due to wrong advice of the learned advocate at filed. This is not a Milord proper ground for delay. And Milord, there is no other ground. And he filed a revisional application which is pending according to him, Milord, until or unless it is adjudicated how which is appropriate, revisional or appeal, who will adjudicate these issues.
Because court has not come to a findings
Yes,
that this
Milord.
revisional
Yes,
application
Milord.
is not maintainable.
Yeah, and he not withdrawn this case. Milord, what Milord, I filed one case, Milord, it is pending before the Lalipur court after Milord losing under section 6 of Specific Relief Act due to my ignorance may file title appeal. Thereafter came to know it would be revision instead of appeal. Milord, I withdrawn this case. Until or unless withdrawn, how came to know which
Section
is
14 will be applicable, limited.
Yes, Section 14 will be applicable, my lord.
No, if it is dismissed or non-maintainable.
Necessary. My lord, it is clear, my lord, from the statute that appeal is required to be filed against the dismissal of an appeal.
The application
It is not at
filed,
all required
he's
to be
also
adjudicated.
learned advocate. He's also learned advocate.
No, I am
You are
not
also
the advocate in that
same
proceeding.
fraternity. Well, entire allegation against the advocate that misguided by the learned advocate file a revisional application. Misguided by learned advocate not in a position to file a proper application. So which is the appropriate application? It is not under jurisdiction of the honorable court, Milord. So,
Yes.
Milord, revisional application is pending. Revisional application is pending without
bench is available if your lordship allow the section.
yes,
of the application.
during pendency of this revisional application, Milord, it is not maintainable.
Okay, take note. Learned advocates for the parties are present. Hard learned advocates on the application for condonation of delay. The delay in filing this application for condonation is about 2 years. It is the contention of the petitioner appellant that pursuant to the judgment passed in title appeal number 30 of 2024 by the learned district judge Paschim Medinipur on May 10, 2024, a civil revisional application is filed on August 6, 2024. Stop. Learned advocate for the petition appellant draws attention to the information slip regarding filing of civil revisional application. It is further contended that in the third week of January 2026, the petitioner, upon being advised with regard to preferring this appeal by the present learned advocate, has preferred this instant appeal along with the condonation of delay. Stop. learned advocate appearing for the respondents submits that the appellant has not shown any other ground save and except putting blame upon the learned advocate. Learned advocate further submits that the earlier revisional application is also not withdrawn as not maintainable. Stop. Upon hearing the learned advocates and considering the facts of the case and relevant judicial decision, this court is of the view that it is well settled that a litigant does not suffer due to wrong advice of the learned advocate. It is also clear that when a revisional application is not maintainable due to the provisions of appeal.
No, I am not submitting not maintainable.
Your learned friend has submitted. Revisional application is not maintainable due to the existence of provision of appeal. The same revisional application ought not to be filed. Learned, the petitioner, appellant, upon showing the facts of filing this revisional application and thereafter obtaining necessary advice, has made out grounds for condoning the delay. Thus, upon considering the grounds furnished, this court is of the view that the grounds are sufficient and the delay in preferring this appeal should be condoned. Thus, delay in preferring this appeal is condoned. This application CAN 2 of 2026 stands disposed. Let this matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission.
I'm with. But only one thing, my lord.
Yes.
This order not will be influenced by the lower court, my lord.
How? I have disposed the matter.
Yes, my lord. By showing this order, the lower court.
Very well. Let the court be convinced. Whatever the court is convinced, let the court be convinced.
That is going on, my lord, today. That is a problem.
No. You see, similar problems may be faced by you also. When you come to move an appeal, the appeal is not admitted. In the meantime, execution is carried out. Same problem will be faced by your clients also.
Yes, my lord.
So let us do something needful.
Monishankar Chakrabarty. OP 1 and 2 লিখে দিয়ে পড়ো OP 1 and 2 লিখে
Lordship, last occasion, as per your lordship's direction, I have served further to the defendant, respondent, but no one appeared, lordship. Last occasion also they are, lordships received and affidavit service also filed. And second time, as per your lordship direction, I have filed. This is condonation of delay application.
Okay, I'm making it as a last chance next Wednesday. Learned advocate for the appellant is present. None appears. None appears in spite of service of notice. Let this matter appear on 17/6/2026 as a last chance.
Lordship, so grateful. Hello, affidavit service to the affidavit service to the উপরে দিয়ে দিল
Yes. Whose application?
Their application.
Okay, not today. Yes, call the fixed matter. Passover matter.
55, my lord.
Both parties are present. Yes, 55.
My lord, there are 3 CAN applications if my lord takes up. দুই তিন চার তিনটে আছে
What is this applications for?
These are all for substitution, my lord, and addition or expunging of the.
You are
text,
for
my lord.
appellant.
I'm for the appellant, my lord.
You are for?
If I may submit, my lord. There was a can 2 of 2022.
Can 2 of 2022, yes.
Yes, my lord will see, my lord, I have attached the death certificate at page 10.
Appellant number 4.
This is can 2 of 2022, my lord.
Yes, who died?
Yes, my lord. Swadesh Ranjan Sannal, that is appellant number 1. Thereafter, my lord, Devashish Kumar Sannal, appellant number 4. And Lokhi Pratima Mitro or Moitro, who is the respondent number 5 therein. For them, my lord, I have named the legal heirs as page 2 of the application as well, my lord. Page 3 as of the application, my lord. At the cause title. এই তো পেজটিতে নামগুলো লিখে দিয়েছি। হ্যাঁ, আচ্ছা ঠিক।
You are for respondent number?
All the respondents, my lord, one of the respondents of them have died since I was the petitioner, my lord.
You are for respondent number?
Respondent number 2 respondent. Omita Das or Omita? Pratap Kumar Das or Omita Das? Respondent number 1 and 2.
1 and 2. That means 2 died. 2 died. Respondent number 2 died.
5 died, my lord.
5 died. You are representing respondent number 1, 2, 3, and 4.
1 and 2.
Okay. Yes, record and order.
Plaintiff's respondents.
Learned advocate for the applicant and the learned advocate. You are representing the heirs of the deceased appellant. Learned advocates for the applicant and learned advocate for respondent number 1 and 2 are present. This application can 2 of 2022 is filed for recording the death of respondent number.
My lord, the appellant number
Appellant
1,
number 1, appellant number 4, and
appellant number 5.
No, appellant number 1, appellant number 4, and appellant number
5 is there, Partho Ranjan Sannal.
So 1, 4, and 5.
Yes, my lord.
1, 4, and 5, and respondent
5. He was the she was the pro forma respondent in the
appellant number 1, 4, 5 as well as respondent number 5.
Yes, ma'am.
3 appellants and 1 respondent. Appellant number 1, 4, and 5 and respondent number 5. Peruse the petition filed, considered. The applicants in the application have shown sufficient ground for condoning the delay. Thus, delay in filing this application is condoned. Abatement, if any, is set aside. The names of the appellant number 1, 4, and 5 be deleted, and the names of the applicants as mentioned in paragraph
paragraph, my lord, 3 and 4, my lord.
3 and 4 of the application, paragraph 3 of the application be substituted in their place and state. Stop.
Well, let it be 3 to 6, my lord. I have described the entire thing from paragraph 3 to paragraph 6 of the application.
Okay, paragraph 3 to 6 of the application. The amendment be carried out within 2 weeks.
Well, there is another can subsequently, that is can 3 of 2022. Another person died.
No, question is first led, unless this one is carried out, it will not have any effect. Okay.
My lord, actually, my lord,
Let this
there is some difficulty, my lord. Pendency of this can, another person died for whom I was seeking this application. Kindly take up can 3 of 2022.
Can 3, who died?
Here, my lord, defendant number, appellant number 1, Swadesh Ranjan Sanal died.
Okay, this application, CAN 3 of 2026 is taken up for 2000, CAN 3 of 2022 is taken up for consideration. This application is filed for recording the death of respondent number 1. Appellant number?
1.
One has already died in the previous.
No, my lord. Oh, my lord, my mistake, my lord. 1, 3, and appellant number 1, appellant number 4, and appellant number 5.
Okay, it's better you come with a list of
My lord,
dates. Okay, on the next date.
List is there at page 5.
No. You come with a list of dates with all with 3 applications. I'll take it up on next Wednesday. Let this matter appear on 17/6/2026. Both 3 applications you come with separate dates.
It is there at CAN 4 as well, my lord. CAN 4 of 2025.
Otherwise, you see, it will be mixed up.
No, I was only placing.
Because you have taken up
I was
all.
placing chronologically, but at CAN 4, finals.
Better you come with a list of dates with 3 applications.
All the 3 applications.
Yes.
My lord, the item number 1, my lord, I am only paying for, my lord, not this week.
My lord, in this matter, I am respondent and cross objectors. My lord, 3 senior brief holders of this appellant. Mr. Rajesh Singh is out of
Not this week.
No, my lord, kindly fixed a date.
Let it appear as to be mentioned.
No, my lord, kindly fixed. Kindly fixed date, my lord.
Let this matter appear as to be mentioned on 15/6/2026.
Much obliged.
Thereafter, I shall fix the date. 15 15 তারিখে to be mentioned থাকবে.
Much. Lords was heard this matter on yesterday. Directed both the parties to prepare the notes of argument.
Yes.
Annexing the judgments and have prepared the same.
Lady Lordship will kindly recall, my lord, yesterday I made submissions. This bill was filed on 2 grounds.
So far, 1/5 is concerned, I am not.
1/5 has to be 1/4. That is the law. That was a mistake. And the second part is
Taxation has to be deducted.
whether
it will be on net amount or gross amount.
No, taxation has to be deducted. It's well
My lord,
settled.
before, my lord, may I just place a judgment, my lord?
Just
You
have, yes.
My lord, this is a judgment of the Honorable Supreme Court reported in
But I have
510 Supreme Court cases 720, my lord.
Yes.
The lordships will kindly travel to para 10, my lord. May I place it? The assessment of damages to compensate the dependents is based with difficulties because from the nature of things it has to take into account many kindly take para 11, that will be proper. The manner of arriving at the damages to ascertain the net income of a deceased available for the support of himself. That is what it is after deduction of statutory expenses. Support of himself and his dependents, and to deduct therefrom such part of his income as the deceased was accustomed to spend upon himself as regard as both self-maintenance and pleasure, and to ascertain what part of his net income the deceased was accustomed to spend for the benefit of the dependents. So my specific prayer is, my lord, they have proved the TDS certificate subsequently, and my lord, I cannot, because cross-examination was declined, so I cannot make any submission on that. But the fact remains the net income that disclosed in the TDS certificate has to be considered as income
Okay,
of
let
the
me consider these decisions.
my lord.
No, Justice SB Sinha's decision, let me see. Justice SB Sinha and Justice Bedi. You see, this point, this assessment of damage, that is also you see paragraph 9 of your decision tallies with this decision, para 10. Yes, you have relied upon these decisions, but nowhere it shows that income tax cannot be deducted to ascertain the compensation.
Record in 2008 volume 2 760.
Page
760.
2000?
8.
Yes.
Page 760. First of all, I have read paragraph 9.
Paragraph 9. Yes.
Term income has different connotations for the term income has different connotations for different purposes. The court of law having regard to the change in social conditions must also question not only having regard to the pay packet the employee carries at home at the end of the month, but also other stocks which are beneficial to the members of the entire family, loss caused to the family on the death of a year or year one can hardly be compensated on the monetary terms. But so far my case is concerned, this has been deducted under chapter 6A. Deduction has been made under chapter 6A. 6A is carries. Chapter 6A carries income of the taxpayer which has been deduction is being provided to the taxpayer on account of insurance payment, on account of medical on account of medical uh, medical insurance premium, donation to charitable trust, and other and interest on loan. Section paragraph 9 is saying the term income has different connotation for different purposes. A court of law having regard to the change in social condition
Yes.
must consider the question not only having regard to the pay package the employee carries at home at the end of the but also other perks which are beneficial to the members. These are all beneficial for the benefit of the same. I am being deducted. Have been
So only income tax, others are not being deducted, only tax, profession tax and income tax. This is not a benefit given to you.
Yes, this is the benefit. Chapter 6 has been deducted.
Income tax is not a benefit. It is some imposition upon you.
Deduction, so far deduction is conduct that is deducted under chapter 6A.
Income tax act has nothing to do with the compensation.
Definitely.
Para 9, what does para 9 say? Income. Para 9, para 9.
Para 9 says the term income has different connotation for different purposes. A court of law having regard to the change in social conditions must consider the question not only having regard to the pay packets the employee carries home at the end of month, but also other perks which are beneficial to the members of the entire family. Loss caused to the family on the death of a near and dear one can hardly be compensated on a monetary terms. Next. Thereafter, I rely paragraph 10. The section 168 just compensation which in our opinion could be assigned on board meaning. We cannot, in determining the issue involved in the matter, loss of sight of the fact that the private sector companies in place of introduction of pension scheme take
Which paragraph you are reading?
next paragraph 10.
10.
I have referred the judgment paragraph 9, 10, 13, 14, 16, 19, 21. These are the paragraph I have referred. Section 168 of the Act uses the word just compensation, which in our opinion should be assigned a board meaning. We cannot, in determining the issue involved in the matter, lose sight of the fact that the private sector companies in place of introducing a pension scheme take course of payment of contributory provident fund, gratuity and other perks to attack the people who are efficient and hardworking. Different offers made to the officer. Every same may be either in the for the benefit of the employees himself or for the benefit of the entire family. If some facilities are being provided whereby the entire family stands to benefit, the same in our opinion must be held to be relevant for the purpose of computation of the total income on the basis whereof the amount of compensation payable for the death of the kith and kin of the applicants is required to be determined. For the aforesaid, we may notice the element of pay paid to the deceased, basic convenience allowances, rent, such and such bonus, Additional above is other benefits were given in LTA reimbursement, medical reimbursement, superannuation, such and such. This has been recorded. There.
You see, read paragraph 14 also. Para 14.
Question came for consideration before the learned single judge of the Madras High Court in National Institute of Limited versus Padmavati, wherein it is held the income tax proportional which are deducted from the salaried person goes to the office of the government under specific date and there is no return, whereas the general provident fund, special provident fund, LIC contribution are amount paid under the specific heads, and the contribution is always repayable to an employee at the time of voluntary retirement, death, or any other reason. Such contribution made by the salaried person are deferred payment and their savings. The Supreme Court as well as the various High Court have held that the compensation payable under the Motor Vehicles Act is a statutory and that the deferred payment made by the employees are contractual. Court have held there cannot be any deduction in the statutory compensation. If the legal representative are entitled to lump sum payment under the contractual liability, if the contribution made by the employee which are otherwise savings from the salary are deducted from the gross income and only the net income is taken into computation for dependency of the government, then the legal representative of the victim would lose considerable portion of the income. In view of the settle of law, I am of the view the tribunal can take only the statutory deduction such as income tax and professional tax and any other contribution which is not repayable to the employer from the salary of the deceased person while determining the monthly income for computing the dependency of the compensation. Any contribution made by the during his lifetime from the part of the salary and then should be included in the monthly income while computing the dependency of the compensation. In my case, what happens, you will also kindly come to the income tax return of 2015, which I have annexed with my notes of certificate. I've placed it with the Joseph certificate.
Yes, certificate copy of
the order and the income tax return which has been.
No, regarding income there is no dispute, whatever it is.
I'm coming to that. Deduction, that part of deduction I'm reading. Yeah. Everyone also got it, man?
Yes, 2015-16.
That's a kind of deduction under chapter 6A. Everyone also got it, man?
Yes, deduction under chapter.
Column C. Column C.
Yes.
Deduction under chapter 6 said that is, they are saying that this will not be considered as the income of the deceased.
No question here. The only pertinent question is, in order to ascertain the compensation, the deduction, that is income tax deduction, has to be made.
The first deduction was under under section 80C. That is 1,34,900.
1,34,090.
90. I'm sorry, 90. That chapter 18C covers the investment of 1.5 lakhs annually if PLS life insurance premium and Sukanya Samriddhi Act. This is the 80C. This is according to the judgment of this honorable Apex Court. this has to be considered as income of the deceased, and they are getting the benefit of this.
You see, whatever is reflected in your form, okay, the learned court has considered those. Whatever,
Has not considered those.
no, whatever, you see, whatever form you have exhibited, on the basis of that, the income has to be considered. So, what was considered? Let us see that.
Learned court below.
Yes.
Court below has considered lump sum 1 lakh. That's why I filed the cross appeal.
No, no, 1 lakh compensation.
1 lakh as a
Yearly income, yearly income.
No, no, that cannot be because
That's why I filed the cross appeal.
That was one of the ground of challenge, that it could not have been considered in that manner. It has to be notional income.
That is their challenge.
That was my challenge. And subsequently now they have proved it. So my contention is,
so, as per the evidence, before the trial court, what will be his income?
Malad, may I just reply to 2 minutes reply, Malad? Malad,
But according to the income tax return, my income comes to rupees 4,15,668 per annum.
You have filed in supplementary paper?
No, I have annexed the same. This is the
Okay.
certified copy.
Okay, this is the certified page. Which page of the paper book?
Not in the paper.
Oh, okay, this one.
This one. This is certified copy. Whole lakh gross total income. Assessment year 2015-2016. Gross total income 4,15,668.
Yes, as per gross total income of the incumbent is 4,15,000.
668.
Okay, and the total deduction is 1,43,142.
142. So
And-
far, I am
And now the question is, now the taxable income is 2,72,530.
Right.
You have to pay tax on 2,72,530. So, out of which you have paid total tax of 2,253 per month. Total tax payable 2,253. How much tax you paid?
2253.
total.
2,72,530.
530.
Okay. And now the total tax payable is 2,253 as per the deposition. So after deducting the tax, income tax,
But these are what I am on, whether this deduction will be considered as an income of the deceased or not.
no question. You see, the court is concerned with your taxable income. This is your income.
No, man, it is also my income. This is being benefit I have been provided. 18C is the benefit. what is 18C? 18C is the investment under the PPF, EPF, ELSS, life insurance premium, and Sukarna Samriddhi.
Okay, if you are earning any interest on those investments, they will be taken to be your income. Okay, you may invest in different shares. You may invest.
Different share, LIC premium. If I pay the LIC,
Yes, yes.
that will be deducted. That will be considered is not taxable.
No. That's a different. You forget that. Whatever from your total income, whatever tax you have to pay, that will be deducted. There is no dispute with regard to that. You may get many benefits for LIC.
Benefit for this.
You get several benefits. That is for the income tax purpose. After the income tax purpose is over, tax is already deducted. That chapter is over. Now you come to the compensation part. Now compensation part, only your income. Okay, that means what you get, what goes to your, what remain in your pocket. Okay, not go what goes out.
If 1,34,000.
Why? How? From where do you earn? Definitely from your salary, from your business. There may be other sources. Okay, that is reflected on that you pay tax. On the basis of different income, you pay tax.
Whether 18C
So nothing is to be considered with 18C or 18E. Whatever income you earn, you pay tax on that.
For the income I have earned, that is 4,15,668.
Very well, what 4 lakh? So you, whatever income, whatever gross total income, from that you get certain deduction for the purpose of tax purpose. Okay, for the purpose of tax purpose. There are certain income, but these are not taken. If you invest in provident fund and this others, LIC, and you get some exemption up to a particular limit. You get some exemption. So that exemption, the court has nothing to do with exemption. Court is the claim cases are concerned how much comes to your pocket. Okay, not what you invest. How much comes to your pocket and how much you spend for yourself and family.
Referred my judgment and delivered the judgment.
Oh, refer to your judgment of?
The judgment which I have annexed with my notes of argument.
Okay, this one, that is just. Yes, now both of you give your own calculation.
Malad, may I just 1 minute reply to that, Malad? What has been submitted? Malad, these judgments which have been these judgments which has been placed before your lordships, Malad, these considers the extra income that an employee may get apart from a salary. But so far here is concerned, Malad, the original person who died but deceased, he has made the declaration for tax. And the claimants, Malad, so far these deductions are concerned, these are investments. They will get benefit of this investment subsequently. Now, if the judgment that I have referred to, Malad, it says ascertain the net income of the deceased available for the support. Malad, what these deductions, these ATC deductions, what he used to get is the taxable income. And that was supposed to be his income to support his family. Now, this 2,72,513, that is the income that he takes home, and that is the income from which he supports his family. So income as a compensation has to be constituted, calculated, keeping that in concern. Malad, I have made a calculation. I couldn't. Malad, that is my case. Malad, nothing more. Malad, so far the gross is concerned, the gross is.
Anyway, you give your notes and your
notes. This is the only
calculation. Give your
calculation. I'll. And that deduction part, Malad,
deduction
they have accepted, so it has to be 1/4.
So you have reflected that in your calculation.
Yes. Because Malad, it's there in the judgment. Probably it's a mistake on the part of the lawyer. Because there are 5 dependents.
So far that is concerned, I have nothing.
You see, one thing, you suppose, now suppose you want 50,000 per month, okay? From your earning, you are maintaining your family, you are paying for LIC premium, paying for shares, paying for GPF, so many things. It is coming from your income, okay? From your income only, those investment can be made. If there is no income, there is no scope for any investment. So, but simplicity, the income tax authority will not charge you on your 50,000 income. They will take into consideration how much you have spent, this 5,000, 10,000, whatever it is. So they will adjust that. And on the basis of that, they will tax your income.
Giving some benefits.
These things are going from your pocket to the investment. Okay. It's not that it is a.
The deceased family will get the benefit of the same.
Deceased family will get what the deceased used to get. If the deceased used to get 50,000 or less 1,000 tax, 49,000. If the deceased used to get 1 lakh, 1,000, whatever is remaining after.
That is my case, my lord. That whatever the investment I have done, that is investment I am entitled to. That is from my income. That is to be considered as my income.
That means how much income is first of all, how much comes to you?
And that is 2,70,000. 14 days. As it is. Hmm. लाख 81,700 81,700 তোমার ক্যালকুলেশন অন বিহাফ অফ দ্য ক্লেমেন্ট ছিল না? ঠিক আছে, এটা দিয়ে
So according to you, the income tax has to be deducted from the gross total income. Only from gross total income minus the income tax, that amount should be taken into consideration. That means these are the amount 44,15,668 was your earning from your business as well as
Other sources.
other investment. And out of that, you see 2 lakh, your deduction was 2,253.
2,253. Deduction was not, deduction was 1,43,142.
No, 4,15,668.
Yes, sir.
Deduction is 1 lakh.
43,142.
No, but you have said, oh, 1/4 is for this personal expenses. That means 3,11,751. 3 crore.
Yours, can you give me once?
This one.
But it is 4,15,668, 1/4, 1 lakh.
It is deducted.
1,03,970 was deducted. It comes to 3,11,751. Now it's loss of estate and funeral expenses 70,000. It comes to 3,81,751. Multiply 14.
No, first is this 4,15,668.
Yes.
That means from that tax deducted is how much? 1 lakh?
1,43,142.
Okay, that has to be deducted.
According to them.
No, from your side.
Yes, sir.
No, 1,43,000. Oh, not total deduction is one thing, and tax deduction is another thing.
Tax deduction is well.
I'm asking tax deduction, not those deduction for the income tax purpose. Anyway, come at 2 p.m. I shall deliver the judgment. Clarify, get ready, come at 2 p.m.
উপরেই তো আছে ঠিক আছে
2 p.m. এটাকে কল করে দেবেন আর
Great.
কন্টিনিউ ম্যাটার
ওই যেটা জাজমেন্ট দেবে বলে
কন্টিনিউ
জাজমেন্টটা না হ্যাঁ হ্যাঁ আর না না জাজমেন্ট
Yes.
জাজমেন্ট
Yes, you have submitted
What, my lord?
the calculation.
Calculation I have given.
So regarding your stand is this yearly income is 4,15,668 and then deduction 1/4 personal expenses,
My lord.
then that is 3,11,000
My lord.
751.
751.
This is
3,11,000.
3,11,751.
70,000 is the general damages.
Oh, this is loss of estate plus funeral.
Right.
No, this loss of estate funeral will be are taken up after the total compensations are awarded, not together with this. 3,11,751 multiplied by 14.
14.
So it's better you multiply this 3,11,000 with 14. Now, have you deducted the income tax?
But I have not paid any income tax. I am not
No, that 2203. Income tax paid is how much?
Total tax paid 280.
So deduct that. So tax paid is not
280. 280.
280 just no, total tax paid here is 2253. Tax payable is 2253. Your certified copy, this.
Yes, ma'am.
It's better you do one thing. 3,11,751, then 2253.
Fine.
Three lakh 14,004. Let us take it as 3,14,000.
So kindly give it to me. I will make a fresh calculation.
3,14,000 multiply by 14. So that on the basis of 3,14,000 multiply by 14.
That 14,000. 3,14,000 into 14. Into 14.
You have taken the future prospect, everything.
Huh?
4396.
4396.
220.
4396. Here 25% cost. 4396. Total got it. 4396. 4396000. Plus 70,000. 70,000.
You have included the future prospect.
25% future prospect.
55, 65, 220.
That is at the with the income. And thereafter you add 70,000 at the end. So for your calculation is concerned, you have proceeded on the net income.
Matlab that is the judgment I have referred. Matlab my contention kindly takes care of that inner loss.
That means no, according to you, tax has to be deducted. There is no
No,
dispute.
matlab my contention is income has to be constitute that part of the income which he takes home and which he can spend. And so far, these ATC deductions are voluntary deductions.
No, but this is also within.
I understand what has been.
That is deduct whatever total income means whatever comes to him. Total income.
Understand. But my
But he is
contention-
getting some benefit as because he has invested in so and so places.
Yes, but
for scheme.
why I was harping on that, these investment, the claimants will get their benefits in the future as well.
So, but that can't be. You see, benefits are only for the purpose of income tax. You see, he is investing in some places.
Anyhow, Mala kindly takes care of that in the judgment.
66 lakh 80,000. 642 according to you.
No. At the bottom.
At the bottom.
That is 54 lakh. 54 lakh 95,000.
Yes, sir. If 54, 95,000, I have added 70,000, 55, 65, 000.
55 lakh 65,000.
My lord.
How much was awarded?
Awarded was just 14
lakh
70,000.
Yes, take down. Learned advocates for the parties are present. Hard learned advocates for the parties. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 17/7/2023 passed by learned additional district judge, second court Purbo Medinipur in MSC case number 115 of 2017. Stop. The claimant respondent number. How many respondents claimants are there?
My lord.
Claimants
but total
The claimants respondent number 1 to 4.
1 to
1 to 5.
1 to 5.
Being also aggrieved by the judgment and award passed by the learned trial court have come up with the cross objection. Stop. The case, next para, the case of the claimants before the learned trial court may be summed up thus. On 20/1/2017 at about 8:30 a.m., the victim Bhagwan Shau, alias Shahu, and Shukanto Padia were returning home by a motorcycle bearing number WB-34 capital G stroke 4334 from Aman filing station within bracket HP oil pump Ashti Mouja ASTIMOUZA. After taking oil, when they came out from the said oil pump, suddenly the offending vehicle bearing number WB-33 capital C stroke 5 WB-33 capital C stroke 6445 within bracket pass, which was coming from Belda side towards Calcutta side with extreme high speed, endangering to human life and safety with zigzag manner without blowing any horn, dashed the said motorcycle along with the victim Bhagwan Shau and Shukanto Padia with great force. Stop. As a result, the said motorcycle was damaged and the victim Bhagavan Shau and Shukanto Padia were seriously injured all over the body, especially on head. Stop. Then and there, they were taken to Belda Hospital, where the attending doctor examined them and declared dead. Stop. The accident was caused due to rash and negligent driving on the part of the driver of the offending vehicle bearing number WB 33 capital C stroke 6445 bus. Stop. The victim was green betel stockist by his profession. Stop. The family members of the victim due to his death are shocked and they are suffering with great economic crisis. Stop. Pursuant to filing of this case, notice was issued upon the opposite party vehicle owner and opposite party insurance company. Stop. Opposite party vehicle owner did not contest the case. Stop. However, the opposite party insurance company contested the case by filing written statement. Stop. The issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 58. Hence it is like A of the. The opposite party, the appellant, Oriental Insurance Company Limited, being aggrieved with regard to the quantum of compensation awarded, has come up with the instant appeal. Stop. The claimants, respondents number 1 to 5, have also filed cross objection challenging the quantum of compensation awarded. Stop. The ground of challenge of the appellant Oriental Insurance Company Limited is that the learned trial court ought not to have based the findings on basis of income of rupees 1 lakh, but the learned judge ought to have proceeded on the basis of some notional income. Proceeded on the basis of some notional income. Stop. The other ground of appeal is that the deduction of personal expenses ought not to be 1/5, but 1/4. Stop. The ground of challenge by the claimants respondent number 1 to 5 is that the claimants respondents number 1 to 5 had yearly income of rupees 4,15,668, but the learned judge erred in proceeding on the basis of rupees 1 lakh. Stop. During the pendency of this appeal, the matter was remitted to the learned trial court for examining the income tax authority. Pursuant to the matter being remitted before the learned trial court, the income tax authority was examined on 14th August 2025, being PW3 of MSCC 115 of 2017. Stop. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that as the claimants, respondents number 1 to 5 have examined the income tax authority in terms of the direction of this court, and as per the evidence of the income tax authority, the gross total income of the incumbent was 14,15,668, and the income tax deducted was rupees 2253. It would be proper to proceed on the basis of the said total income. Stop. Learned advocates for the appellant insurance company has relied upon the following judicial decision. New India Assurance Company Limited versus Charlie and another, reported in 2005 10 SCC 720. In the case of New India Assurance Company Limited versus Charlie and another, the Honorable Supreme Court was pleased to observe as follows. Para 11, ঠিক আছে? Para 11. Learned advocate appearing for the claimants, respondent number 1 to 5, have relied upon the following judicial decisions. Achha, number 1. National Insurance Company Limited versus Indira Srivastav, reported in 2008 within 2008 bracket 2 SCC page 763. Second holo Sunil Sharma and others versus Bachithar Singh and others, reported in 2011 bracket 11 SCC page 425. Third holo New India Assurance Company, আগেরটা বলে দিলাম, দুইটা হয়েছে Sunil Sharma and others versus 2011 11 SCC 425. New India Assurance Company Limited versus Renuka Laha and others, reported in 2013 SCC Online Calcutta 12771. Next holo Manas B. Jain versus Delhi Transport Corporation Limited and others, reported in 2014 13 SCC 22. Upon considering the judicial decisions, it is clear that while computing compensation, the income of the victim that income of the victim will be taken to consideration, which remain after deducting the statutory taxes, namely the income tax and the professional tax. It is also held in different judicial pronouncements that different allowances it is held in the case of National Insurance Company Limited versus Indira Srivastav that for the purpose of arriving that para 9 and 10 ঠিক আছে, that income connotes the follows, ঠিক আছে, para 9 হোল্ড করে দিচ্ছি এখানে। হ্যাঁ, the honorable court further observed as set out para 10. ওটার পরে এই যে এটারই para 10, ঠিক আছে। Thus, it is clear that apart from the statutory taxes, the investments made by the victim, the allowances which are receivable, and the perquisites cannot be deducted for the purpose of arriving at the compensation. In the instant case, as the gross total income of the victim as per the deposition of the income tax authority is rupees 4,15,668. The compensation should be arrived at upon deduction of the income tax from the gross total income. Stop. Although certain deductions are permissible under the Income Tax Act from the gross total income, but the said deductions are only for the purpose of assessment of the income tax, and the same does not have any relation with the rule of computing the compensation in motor accident claim cases. Stop. Hence, although the total taxable income of the victim is rupees 2,72,530, but which is arrived at after making different deductions under the Income Tax Act, but the compensation should be computed after deducting the income tax from rupees 4,15,668. In the event the total income is considered to be rupees 4,15,668, the income tax deducted is rupees 2,253, which comes to rupees 3,14,004. Stop. Yes, you have, yeah, just a minute. You have proceeded, you have submitted upon deduction of 2,253.
Your Lordship has given that, but I could not found any 2,253 amount. I have found that I have paid only rupees 280 as tax.
No, as per the deposition. No. Actually, okay, 3,11,751. Right. 2,253 means 3,14,000. আচ্ছা, ওটা কেটে দিন। In the event the yearly income is rupees 4,15,000, ওটা ওই ইনকামের ওই জায়গাটা আর কি। হ্যাঁ, এবার লিখো। In the event the total income is total annual income is rupees 4,15,668, 1/4 should be deducted on account of personal expenses, and the yearly income comes to rupees 3,11,751. Stop. The income tax which should be deducted as per the deposition of the income tax authority is rupees 2253. Thus, the net income comes to rupees 3,14,004. However, for the purpose of convenience, the annual income, net annual income is considered as 3,14,000. Stop. As the victim was, yes, what was the victim age? 42 years of age. Multiplier of 14 should be applied, and the annual and the total dependency loss comes to rupees 43,96,000. The future prospect of 25% being added comes to rupees 54,95,000. Further, the claimants are entitled to rupees 70,000 on account of loss of estate, funeral expenses, and loss of consortium, which is rupees 70,000. Hence, the total compensation comes to rupees 55,65,000. Stop. However, this court is of the view that rupees 55 lakh is just unreasonable. Hence, this appeal, FMA 323 of 2024, along with COT 42 of 2024, stands disposed. The claimants respondent number 1 to 5 are entitled to compensation of rupees 55 lakh from appellant Oriental Insurance Company Limited of rupees 55 lakh along with interest at the rate of 6% per annum. I'm giving 6%, 6% per annum.
There is no appeal to that effect.
Yes, yes. There is a
No, what is just and reasonable?
The Lord says 55 lakh.
Okay, 55 lakh, 6% per annum.
65,000.
I'm giving 55 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today.
Till realization.
Okay, till such payments, the appellant Oriental Insurance Company Limited shall deposit rupees 55 lakh along with interest within 8 weeks before Registrar General High Court Calcutta within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited.
only 25,000 as statutory.
Is already deposited. The balance amount be deposited. The claimants respondents number 1 to 5 are entitled to withdraw the compensation amount upon compliance of necessary formalities.
Grateful. Watch up.
Yes, item 5.
Item number 5. I am your lordship, the appellant in this case. This is a railway appeal filed by the widow of the victim for the
You are
railway
for?
appellant.
Appellant.
Yes, madam. This appeal was filed by the widow of the victim.
No, who is appearing for this?
Yes. So Chakravarti is there, na? Mr. Chakravarti.
So you start the matter?
Yes. This is a railway appeal which was filed for the accidental death of the husband, an untoward incident. I am just briefly reading the factual aspect of the case, which is, my lord, kindly go to the page 5 of my paper book. I am reading just 3 to 4 lines. Page 5 of my paper book. This is the claim application. at the bottom of the page. Para number 3 at the bottom. The victim on 1/10/2018, the date is important. Why I am coming to that, Your Lordship. The victim on 1/10/2018 came to Boidyobati station, and after completion of his work, he purchased a return journey ticket from Boidyobati to Belur. After completion of his work at Belur, he again boarded a Bandel local train from Belur at night hour with same return journey ticket. During the course of the journey, when the train reached at kilometer post number so and so in between Risra and Srinampur station, the victim at that point of time stood near the door of the compartment and accidentally fell down from train. After the incident, what happened? Being officially informed by the station master of Risra station, which was treated in this case as first information report, investigating officer of Sheurafuli GRPS reached the place of occurrence at 9:55 hours, very soon after the incident, and started one unnatural death case prepared investigation report under 174 CRPC in presence of available witnesses, being UD case number so and so, and the photocopy of such inquest report, FIR, final report, and seizure list, which was annexed with the claim application in the tribunal. And all such documents, Your Lordship, was exhibited. I am coming to that. Now, I am reading just the Your Lordship, well aware of the provision section 124A, which reads as compensation on account of untoward incident. When in the course of working a railway, an untoward incident occurs, then whether or not there has been any wrongful act, neglect, or default on the part of the railway administration, such as would entitle a passenger who has been injured or the dependent of a passenger who has been killed to maintain an action and recover damages in respect thereof, the railway administration shall, notwithstanding anything contained in any other law, be liable to pay compensation to such extent as may be prescribed to that only for loss occasioned by death or injury to a passenger as a result of such untoward incident. Here the victim fell down from running train, which comes under the provision of the untoward incident. Now this section is like, Your Lordship, as no fault liability, like the motor vehicles 164 section. Same. This is the no fault liability. And the exception, when the railway administration is not payable, it is a suicide, self-inflicted injury, his own criminal act, and any act committed by him in state of intoxication. So in this case, nothing was proved by the respondent.
So after the incident, forthwith the matter was reported.
Yes.
Not that the body was found from the track and on the morning.
Body was found on the track?
No.
Yes, Your
He fell down at what time?
Fell down at, Your Honor, at night, before 9 p.m.
Before 9 p.m. Body was recovered when?
Body was recovered, I am coming to that. Thanks to the inquest report, Your Honor. FIR, I am coming to the it's 75. It's 75. 25. I'm coming to the final report. Station number and date of first information, reference Sevrafuli GRPS number so and so. Date and hour of going to the spot 1/10/2018 at 21:55 hours. This is the page number 76. I am reading this page number 76 of my paper book, and the HCR is also there. During investigation of the UD case, SI RS Sheikh of Sevrafuli GRPS arrived at the post in between rivers upline and between Risra and Srinampur within the station limit of Risra, and found one unknown male person, aged about 35 years, was lying in between rivers and up main line between Risra and Srinampur railway station. So the body was found in the railway premises itself within the station limit of Risra. Gateman was first came to know about the incident of accident, and thereafter he reported to the concerned station master, and station master reported to the incident to the investigating agents. This is the case. So the PO and prepared the rough sketch map of the place of occurrence with its index and 2 photographs of the place of occurrence, including the dead body from different corners. Prepared Surothal report over the unknown male dead body, aged about 35 years, in presence of local witness. After preparing Surothal report, send the dead body to Srirampur Walsh Hospital, police morgue for PM examination, Your Lordship. Now the second paragraph of page 76 of final report, which was exhibited. During investigation of the case, I tried to trace about whereabout of the deceased on asking the local public, but they failed to identify the dead body, and also nobody could say anything whereabouts of the deceased. In course of the investigation, it was transpired from the Surothal and local witnesses that perhaps the deceased hit by the railway signal post near gate number so and so. The Surothal witness and local witnesses opined that the deceased seems to be fell down from a running train, and due to this received grievous injuries. And the third paragraph of the final report, at the same time, two PS Dome searched the unknown male person dead body and found one railway ticket which was produced by the PS Dome, Kartik Dome, name so and so, line number. And accordingly, the investigating officer prepared a seizure list and seized the ticket as Alamat. And the seizure list I have also produced, which is marked as exhibit. Seizure list is marked as exhibit, Your Lordship, A3. Now, I am coming another point why just now, my lord, there is the rule, the Railway Passenger Manner Investigation Rules 2003. As per the rules, whenever any untoward incident happened, report about untoward incident. Any railway servant, including guard and driver, who came to know about the incident of accident, he has to report to the nearest station master. And thereafter, the investigation began. Now, in the rules, it is categorically stated what is the difference between force and police. Police, in this case, Your Lordship, force means the Railway Protection Force. It is clearly written. And police is the government. CRPS. So, as per the rules, they are the authorized investigating agency. Now, why I am reading to this, another important point in this case, which is very conducting number 7. At number 7 of the
page
101, this is the rules I am reading, Your Lordship.
Yes.
Conducting of investigation and submission of report by force. There is two specific provisions.
See, one is before the UD case is by the GRPS. The other is by the Railway Authority who conducts their own inquiry.
An inquiry. That is like the internal inquiry done by the investigator in the motor accident claims cases.
Yes, that is the department. That is the Railway Authority's inquiry by the RPF.
Yes.
And the other is the police UD case.
Yes, UD case. 174 CRPC, the report is prepared. Now, most important thing in this case, the rule says on conducting investigation and submission report by force. Thereafter, it comes on receipt of information under Rule 6, and officer of the force shall carry out the investigation and shall obtain copies of the inquest report, post-mortem report, Jama Talashi report from the police investigation incident. Categorically, what their authority is, they have to collect the documents from the GRPS, obtain a copy of report specified under clause 3, record statement of additional witnesses if so required. In this case, no additional witnesses statement they recorded. And the most importantly, the officer of the force shall complete the investigation within 60 days. Whenever the untoward incident occurred, as soon as the matter is reported to the authority, from that, within 60 days, they have to submit their report
to the DRM.
To the DRM, which is Divisional Railway Manager's report. Now, why I am reading this book, I am coming to that point. And thereafter, it is written conducting investigation of submission of report by GRPS. They are the main investigating authority. Now, Your Lordship, in this particular case, two issues are generally involved, Your Lordship knows. Whether the incident is an untoward incident or not, and whether the victim was a bona fide passenger or not. This is the simple two issues. Now, regarding the bona fideness, now in this case, Your Lordship, as per the exhibit A3, the seizure list is there.
Page?
Just telling Your Lordship. Seizure list বলে দিচ্ছি। Investigation report 70 থেকে 77, 70 থেকে 77। Page 72 of my
Page 22,
72 of my paper.
72.
The LCR is also there, Your Lordship.
Yes.
This is exhibited. From the time it is crystal clear, reference Seurapuli GRPS UD case number 82 and also date and time of seizure 1/10/2018 in between 11 p.m. to 11:15 p.m. That is during the investigation report, during the inquiry.
No, this is by the police.
This is by the GRPS.
GRPS. Page 72.
Page 72. The seizure list which was exhibited in the tribunal also. And place of seizure, time of seizure is after the during the inquest 23 to the 11 p.m. to 11:15 p.m. Place of seizure in the place of occurrence itself, kilometer post number so and so near LC gate number. Name and address of the witnesses. Now Constable 2016 Tushar of discharge GRPB, Constable Lukman Ali RPF.
That is page?
No, this is in the seizure list, Your Lordship.
Yes.
Seizure list itself. Who are the witnesses in the seizure witness? They are the seizure witness. They are the seizure witnesses. 3 persons is there, signatories. One is Constable Tarok Kanti Mahato, one is Constable of RPF itself, Lokman Ali, RPF. And number 3, another Constable, Sham, something is written. And in the seized one railway ticket having ticket number so and so dated 1/10/2018, that is the date of incident. So the ticket is clearly valid from Boidyopati to Belu, origin station and destination station, Your Lordship. For one return journey till midnight, the above noted railway ticket was produced by Kartikram during Surathal of the dead body at place of occurrence. The above noted railway ticket seized as alamat. So therefore, my contention is that, Your Lordship, the initial burden is well discharged by the appellant that the victim was a bona fide passenger. From the police report itself transpires. The ticket was found the possession of the victim, and soon after the incident, it was recovered, and accordingly, seizure list is prepared. So now the definition of passenger is that the person who is traveling with a valid journey ticket, he is treated as passenger as per the Railways Act. This person's body was found from the railway premises itself. This is also transferred from the
Railway track.
Railway track, outside the railway track. After the fall down from train, usually the dead body is found outside the railway track. So this is not the case of the railway that the incident happened in the outer premises, another limit of railway premises. This is within the station limit of the railway premises. And mainly they have denied, Your Honor, the bona fideness basically on the statement of the one signatory of the RPF. Your Lordship goes through the judgment of the tribunal below. Only this issue has been considered.
Page.
Judgment, Your Lordship, 43 to 49 of my paper book. These two issues are involved: whether the incident on account of which the victim is alleged to have died termed as untoward incident, whether the victim was a bona fide passenger or not. Now, in the judgment, Your Lordship, page number 44, it is mentioned the applicant had filed certain documents duly certified by the competent authority.
Yes, page 49.
Page 44 of my paper book, Your Lordship.
Yes.
Page 44, paper book, paragraph number 4. The judgment itself, it is written, the applicants filed certain documents duly certified by the competent authority. That is the GRP. Those documents were exhibited, namely investigation report A1, FIR A2, seizure list A3, dead body challan A4, postmortem report A5, final police report A6, and one letter of Seurapuli GRPS, so and so. And in the entire judgment, this 5 pages judgment, one thing is considered, that is the statement of Lokman Ali, who is one of the signatory in the seizure list.
What is his statement? Let us see.
when he was called by the tribunal, this Lokmalani, he told that he signed in a blank scissor list. This statement is also here.
Let us see page.
Yes, page. This is for page 42. 4 persons were 3 persons signed in the inquest report, scissor list. Only the RPF person was called by the tribunal. Page number 42 of my DRM report, the paper book, Your Lordship.
Yes.
My name is Lukman Ali. I have been working as head constable RPF at RPF so and
Page
so.
42. Yes, yes, yes.
Page 42, Your Lordship. Your Lordship got it? Page
Yes.
42, yes. He was called as a court witness. Examiner Lukman Ali. Respondent witness, Your Lordship, not court witness. On 1/10/2018, I was on duty RPF outpost Srirampur from 14 hours to 22 hours. On that day, on duty gateman LC number so and so Pradeep Shil had informed me that one male person was lying dead between up main line and reverse line, and immediately I reached the spot. After that, SI RPF Mrityunjoy Mondal also reached the spot. This person was not examined by the tribunal. RPF Mrityunjoy Mondal reached the spot, and thereafter GRP personnel reached the spot. Room of GRP searched the body, and Jama Talashi was done in my presence, and during that process, no railway ticket was recovered from the possession of the dead body. This is the statement. And on that very basis, this statement, the entire documentary evidence produced by the prepared by the competent authority was rejected. The inquest report was rejected, the scissor list was rejected, the final report was rejected, only because of the statement. Now, Your Lordship, why I am read that provision, particular the manner of investigation rules, it is clearly written that the investigation has to be done within 2 years, 60 days from the date of occurrence. 2 months. That is mandatorily. Now, Your Lordship, the incident happened on 1/10/2018. Date of incident is 1st October 2018. That means the entire investigation from the part of the internal agency RPF has to be completed within 2 months. That is by December 2018. And they had to submit the DRM report. Now, in this particular case, Your Lordship, the DRM report, which is their document, DRM report is, Your Lordship, in my paper book, page 17 to 38. And Your Lordship, come to the page 17. Page 17 of the DRM report. This is the first page of the report. Now, when this report is submitted, that is most important, Your Lordship.
Oh.
This DRM report is submitted.
Page
17. DRM report is page from 17 to page 38. This is the total DRM report. Start from page 17 of my paper book.
Yes.
Yes. This is the front page of the DRM report. Senior Divisional Security Commissioner, RPF Eastern Railway, Howrah. Now the date, kindly, Your Lordship, see the date. 22/12/2020. After 2 years, they have submitted that investigation report. This DRM report itself lost its credence. And what the RPF has told, after 2 years, the investigation is done by the respondent RPF itself.
So where is the residence of this person?
This person's residence, Your Lordship, residence of
the victim?
Victim residence is Kajipara, PO Boidyobati, PS Srirampur, district Hooghly.
Okay. That is Boidyobati. And where did the incident take place?
This incident took place, Your Lordship.
Isha and Srirampur.
Yeah. So my contention, Your Lordship, is that the report which is prepared by the RPF statutory.
This person had ticket from Boidyobati to?
Boidyobati, Your Lordship, the ticket is Boidyobati to Belur for obtaining return journey till midnight.
Oh, that was the return ticket.
Return ticket was
Buddhopati to Belur and back.
correct. Ticket is valid on that date.
Yes.
So my contention is that the DRM report is of no value, which is prepared after 2 years, and what the RPF told before the tribunal after 2 years, that I have not signed in the Caesar list. I have the Caesar list part was blank. And towards that, I am giving the judgment of your lordship itself, which was passed very recently. One is this Khorka Bahadur Chhetri, the judgment was passed by your lordship 2026. The same case, the tribunal hold that the ticket was not found. RPF told that ticket not found. On that basis, the case was dismissed. This is the judgment of your lordship Khorka Bahadur Chhetri, and the same Yelamma. This is the judgment of Karnataka High Court. And the same case that RPF told that the ticket was not found, whereas the statutory investigating agency reported that ticket was found. So I am relying upon these two judgments. Rina Devi judgment is, your lordship already knows that initial burden is discharged from the police report itself. That victim was a bona fide passenger with valid ticket. And once the victim was a bona fide passenger, he fell down from the train and died. That's why he is entitled to the compensation of rupees 8 lakhs.
Yes.
That's all from my point of view.
Okay.
My learned friend has taken, although it's a good story, but in that case, Malar, trial court has categorically said that the victim, the victim person has no ticket. As far as this case is concerned, Malar, you should kindly come to Malar page 23, Malar. The page 23, Malar, paper book. The station master memo, Pradip Shil, gate number Ato, 4B at 21:15. That is 9:15 p.m. Incident took place, Malar. And then, Malar, subsequently, Malar.
Page 23 is the requisition, that is the information.
Yes, yes.
To the station master.
Master memo. Information from gate man of the same station.
Yes.
Then you will actually come to page 26. That is RPF. RPF diary, that is the important part.
Yes.
RPF diary categorically, Malar, made when Malar incident took place, and then Malar subsequent Malar, this force has taken into consideration all legal formalities, and after that,
The matter was reported to GRPS.
Yes, Malar.
And UD case was also started.
Yes, Malar.
This is their internal inquiry.
Yes. That is, time is important, Malar. This is a registration of document, Malar. As far as the railway authority is concerned, Malar. RPF diary is, Malar. After completion of incident, and then Malar subsequent event has been
Okay, let us see this.
That is the registration folio, my lord. You'll see Kali come to my lord, middle portion. The dead body of the victim, all legal formalities at 22:45. No railway ticket was found from the possession of the deceased. Middle portion, my lord. Their preliminary investigation comes, my lord. It is a case of suicide case. Bottom portion, my lord. It is a case of suicide nature. No person came forward to give details information, my lord.
No, it was in the police report. Is there any foul play, suicide or this murder or whatever it is as per the police report? Because they also investigated the matter. They, according to them, it is neither a suicide nor a murder. So, according to them, it is an untoward incident. These are the conflicting report of the police and the railway authority, for which the person is delegated to court.
Yes, sir.
Otherwise, you see, if the ticket is found or whatever it is, if it is a clear, the authorities can grant the compensation.
Yes, my lord. Actually, what happened, my lord, this case, my lord, initially, my lord, RPF has already taken into cognizance this matter, and then subsequently, my lord, Kali come to.
So, this is what is the timing of this one?
Timing is, my lord, 22:45. Investigation completed.
22:45.
That is 10:45 p.m.
Yes, 10:45 p.m.
Yes.
And date is 1:10.
Yes.
And
same date, ma'am, same date.
1:10. And GRPS inquest is at what time?
Yes.
After from the timing of the incident, within 2 hours, the entire investigation process is complete.
No, this is okay. This is
No, your lordship, Kali come to page 72, my lord. Seizure is which garnetment, my lord, shown before arguing myself, my lord. You see, Kali come to bottom portion, my lord. Upper portion, top portion, my lord.
Yes.
Seizure is prepared 1:10, 18 at between 23:05 hours to 23:15. That is 11:05 p.m. to 11:15 p.m. While, my lord, all formalities has been completed at 10:45. Then, my lord,
thereafter they were informed.
Yes, my lord.
The GRPS was informed probably thereafter, and thereafter they came.
That when, my lord, this is a question of, my lord, law and order situation. So, my lord, GRP has the main authority to conduct all the things as far as this is concerned. So, when GRP, my lord, has took place all the formalities, then RPF can, my lord.
First is the
RPF,
station manager was informed.
Yes.
Immediately, I think thereafter the GRPS is also informed, because it will be recorded in the
Station master, then GRP. RPF, then RPF, and RPF informed to the GRP, my lord, authority.
Page 71.
RPF not informed.
Okay, page 71 is the FIR. Okay.
71.
Oh, RPF informed.
Yes, RPF. So, my lord, all formalities has been completed at 10:45 p.m., my lord.
Anyway, information is given to the GRPS, but this UD case inquiry is to be done by the police.
Yes, sir. But as far as seizure list is concerned, my lord, page 272, how can it be proceeding has been started at 11:05 p.m., my lord. That is 23:05 p.m. After completion of all the formalities, that is 10:45. That is recorded.
No, question is you see, the moment they come, they have to do the needful. They have to search the body, if there are any articles, they have to send for postmortem, and whatever publication is to be done, they have to
Postmortem
do.
after that, but
And they have to ascertain the identity of the dead body. So many things the police authority is to do after they are informed. The moment the UD case and after the inquiry, they have to do the inquest also. They are after the inquest, it has to be sent for that under 174.
but important point is which enumerated before the trial court, that is seizure list. The seizure list, my lord, it may be a manufactured document as far as ticket is concerned.
You see, the manufactured means, you see, this is this person, police authority is not the relations of this claimants or the victim. They are the totally third party. They belong neither to the railway nor to the claimants. They are the third party.
Third
So
party,
they have
but-
to carry out the
but
investigation.
something somehow, my lord, investigation at the time point.
Because this person is also not examined. Had this person been examined, he could have faced the cross-examination.
Yes, that
From
is
the
true, my lord.
from the railway side, this person could have been examined. If the railway authority thought that it is a foul play, the railway authority could have examined.
Yes, that is true, my lord. But as far as this seizure list concerned, that is not correct as per this time schedule is concerned, my lord. Because 10:45, the investigation not, the proceeding of dead body has been completed. But
You are submitting wrong, your lordship. If your lordship come to the clear copy is in the LCR investigation report, that is the inquest report.
It is not there in the paper book.
Paper book is just one page is there. 70, page number 70 in the paper book. Kindly come.
that
to
is
the
not
lordship.
totally, my lord. This is a
First page you come to the lordship. Investigation, it will clear what their contention.
There are no mention about ticket, my lord. You should kindly come to my lord, page 70.
No, what you are telling.
Ticket কথা
Okay,
বলাই
the
নেই।
brief facts, yes.
So, kindly,
You should
they are,
kindly come to
they are
investigation
containing the
report.
timing. I am trying to submit your lordship. Case reported on 9.
All the you should kindly come to my lord, investigation report and other
Page
page 70.
70.
70.
Yes.
Annexure P3.
P8.
P8. That is, there are no mention, my lord, regarding seizure list ticket, my lord, ticket number, my lord. So, my lord, whether I do believe this investigation report or my lord seizure report, this is totally contrary. That is why, my lord, judgment, my lord, you should kindly come to judgment paragraph, my lord.
Judgment হচ্ছে what they are contesting, your lordship. They are telling that the seizure list was making afterwards, but not. This is not the fact.
You
Yes.
should kindly come to my lord, page 44, my lord. The trial court, my lord, judgment, my lord. Page 44. Paragraph 3(1).
Yes.
Upon pleadings of both side documents, the issue are recast which as follows: whether the incident of on account which victim is alleged to have died can be termed as an untoward incident as defined under section 123(c)(2) of the Railways Act. Second matter, whether the victim was a bona fide passenger of the train on the date of incident as alleged. Whether the applicant are the dependents of the deceased in terms of section 123(b) Railway Act and are entitled to get compensation from the respondent.
Achha, to whom the body was handed over? The body was
Wife of the deceased, I think.
which page?
That is the dead handover letter is not available with us. Dead body challan is there. After the post-mortem,
No, in the report, in the 174, it should be there.
Yes.
kindly
Then you will kindly come to my page 47, madam.
47.
The inquest report, madam, IO. That is also clear as far as this investigation is concerned, madam. In the inquest report, you should kindly come to my page 47. In the inquest report, the IO opened that this is seemed to have been hit by the signal post and had fallen down from the train, which was reiterated in the final police report also. It is unambiguously indicates that the IO could not ascertain the actual cause of death of the deceased conclusively. Therefore, the opinion of the IO GRP was clearly based on presumption. From the legal point of the view, no judicial order can be passed depending on any statutory report which was prepared on presumption only. Hence, the statutory report cannot be given cognizance to the determine the instant case. Next, my lord, as per the seizure list, one ticket that is number ato was seized by the concerned GRPS, where CW1 stated before court that no ticket was recovered from the possession of the dead body. During examination by the learned counsel for the respondent, he disposed of that he put his signature on the seizure list when it was blank and nothing was written on it. Moreover, no ticket was also filed by the applicant. This is important, Malad. Then, Malad, firstly, on oath, CW1 stated that no ticket was...
Who is this CW1? Clement's witness.
Seizure list witness, Malad.
Okay, seizure list witness.
RPF was found from the possession of deceased. Secondly, CW1 stated that he signed on the seizure list when...
which page? CW1 statement, page 70.
CW1, Malad, page 42. Page 42. Malad, that statement recorded by the Malad RPF investigation officer, Malad. Page 38. What's the next page? Na?
Yes.
And cross was Malad, page 42. 38 and cross Malad, 42. Malad.
42, yes.
Was Malad declared witnesses that no ticket, Malad, no any railway journey ticket, pass PTO was found from the possession of the deceased person at the place of occurrence, and seems it is the case of suicide nature. Last, Malad, last. Page 38, last 2 lines.
Page 38.
2 lines. Page 38, last 2 lines, Malad. And similar cost examination, Malad, that is page 42. Similar statement has been recorded, Malad. That is examination, you see, kindly come to page 42, examination by court. On Atho, I was on duty RPF post, Sirampur from Atho. On the day of duty, gateman LC Gate, Pradip Shil had informed me that one male person was lying dead between up mail line, reserve line, reverse line, and immediately I reached the spot. After that, RPF Mrityunjoy Mondal reached the spot, and thereafter GRP personnel reached the spot. Dome of GRP searched the body. Jamatallashi was done in my presence During that process, no railway ticket was recovered from the possession of the dead body. This is clearly said that no ticket found. And then, the paper bears my signature, but when I put signature on it, it was blank paper. Nothing was written in it. On being approached by GRP personnel, I put signature on the paper. GRP inspector told me that being on duty RPF constable, I have to sign it. I reach the spot within 10 to 15 minutes of occurrence of the incident. So, time gap is very important. 10:45 PM to 11:15. This is half an hour journey within the same site. And only seizure list can count that some ticket is there, but otherwise, investigation, other things, the mentioning of ticket and other admission, nothing.
Okay, so Caesar witness were how many? Three.
Three.
Out of which, how many Caesar witness examined? One.
Particular RPF.
You see, the ticket, this person is a resident of Boddobati.
Not Boddobati, Sirampur.
Boddobati, okay. The ticket which was seized is from Boddobati to
Return ticket.
Boddobati to Belur. This ticket was issued, that means at what point of time?
The return ticket was issued in the morning. He went to the workplace. He was a security guard. At
Okay.
night, he was coming.
No, what was have you stated there? What was his occupation?
Security guard, I have mentioned in my
You have
claim
stated that.
application.
Security guard. Now the question is, this ticket was purchased, this is a return ticket.
Return ticket.
That means definitely it must be issued in the morning. Was the time mentioned?
No, that is not mentioned. That is also not annexed.
No. What was the ticket number? You see, return ticket, if it is in the morning, it is available. It is valid till 9. So
4 hours.
that was the return ticket from Boddobati to Belur and back, return.
As per the Caesar list, it is a return ticket.
And the incident, as per the claimants, took place between Rishra to Sirampur.
Yes, at the time of returning.
That means in which track?
This is when he was.
Because you see, if he is to return from Belur to
Yes.
Sirampur.
When from Belur, he was returning. That time incident happened that night.
Which the body was found in which track?
Rishra and Boddobati. Up main line and reverse line.
Because you see, if you go from Bali side,
Yes.
in Bali, there will be one line going straight towards Howrah. Okay.
Yes.
One platform, there is one line straight from Sirampur to Bali to Howrah. Thereafter the platform.
Yes.
Thereafter, there are two lines. two tracks, or both tracks going towards that Sirampur.
Sketch map is also there, your lordship. I think sketch map is
It is
also
not
there.
a case of accident as per this
Sketch map is
story,
there.
my lord.
Sketch map is there, and where the body is found, this is just outside the
Case
railway
map,
track.
my lord, page
Which
35.
page?
35.
Page 35.
35.
This is where the body was found. There is one up main line, then reverse line, then down line.
Yes, up main line actually. Yes, that is there.
That is there.
No, you see, one is this. There are two down lines in Bali station. Two down lines, only one up line.
Only
Just,
one.
just the reverse. You see, one is this for the goods and this loop lines. The other is this. There is one platform. There are two main lines.
Yes, your lordship. And the
Two down line. There are two down lines.
One up line, one up.
One up line.
one loop line. So
So,
body
Malad,
was
this is
found
a-
upside,
So which side it was found? That is
outside the railway of up line.
Not up line, middle portion up, middle portion up.
No, it's
30 page. 30 page, 35.
35. The place of occurrence is
Incident.
there.
no. Let us see this. You see,
Up main line and reverse line.
PO is written.
left side. You see. Okay, place of occurrence.
Place of
Right,
occurrence
right.
is there. That
Occurrence with dead body found. my
It
lord.
was found after that.
Place of occurrence. This one is the place of occurrence. That means body found.
Yes.
That means upline beside the upline.
Inside the up line.
Thereafter, there are no tracks.
No.
One track. After that, there are no other tracks.
Reverse line. Reverse
Reverse
line
line.
is there.
Reverse line and up line, middle of the reverse and up line. Place
You
of
see.
occurrence is main up main line and reverse line. Middle of the body was found. This now we are always taking story just metro station suicide matter. That is
This is this
they
case is
done-
not proved by them
Yes,
also.
my lord. Huh? main line কাটতে পারে লাইন থেকে এখানে পড়বে কি করে kindly see that photo.
I think when in the upline, after the upline, there is one plat. There must be. Oh, of course. After it has crossed the platform, there must be downline.
Yes.
So,
Reverse.
so upline and downline. Between upline and downline.
This is not down line. This is reverse line. Say, in the
Is the
photograph,
reverse line also
reverse line.
both direction.
Down line, then another part, my lord. That is question, my lord. However, if it is another down line, it can be possible for accident, any accident. But reverse line, reverse line,
When he was returning, his body must be found up line.
No, upline means you see, as you know, but if you have some experience in that side, because you see the main Bali station, there is one platform, one train goes down line, another line, there is another platform. From that platform, the trains can be available both up and down.
And down. In this case, direction of travel matched. The place of occurrence and the direction travel.
Place of occurrence means this is upline and reversible line.
Possible. Railway track towards Rishda.
reversal means
In the reverse line,
bypass train, bypass train.
both direction train passed up down. So place of occurrence is just outside the railway track, which is possible.
The
only
question
after-
is if it is, you see, if the case is this, this was found in the down line and he was not returning to this thing, Bodhobati, then the case goes.
At the time he was returning definitely. That's why that contention was also raised. That was not also raised in the
You see, some third parties are not examined, these employees,
non-examined in this case.
7 except the family.
They were absent the family and only the RPF witness. And from the circumstantial evidence, from the police report, it is a case of fall down from train.
No, that is why, no, it is a fall down. From which side? That is the upline, between upline and the reversible line. Now this is down line and this is loop line.
Only valid ticket, Malad. That is the important thing because Malad, that is not
That was, ticket number is there. Railways have got ample opportunity, whether the ticket was genuine or not, nothing was challenged.
That is not in the
Ticket
investigation.
number was there. They can easily verify that ticket also.
As far as this investigation report is concerned, there are no,
They have not verified the ticket.
They have not verified the ticket.
because investigation not done well. In the investigation,
They have
there are
collected
no
the documents.
mentioning the
That,
ticket.
that means they have not doubted the ticket. They are satisfied from the ticket itself. That is why they did not think fit.
That is on the one way, but another way, he has no valid ticket. That is also valid.
The authority did not think fit to verify the ticket. Otherwise, they could have verified. Whatever is there, they are satisfied.
Clearly, destination, origin, everything is mentioned, ticket number. And what they are telling is not true. During the course of investigation, the Caesar list prepared. That is,
Main question is that under the rules, my lord, Rishi kindly come to the rules, my lord, whether the victim was a bona fide passenger of the train on that date of incident as alleged. That is the important. That is why, my lord, trial court reject this application, my lord.
without any evidence. এটা রেখে দিও, নাম ছিল।
Okay, any other decisions to cite?
Decision, the rules
I have
technically say,
cited your lordship.
page 49, my lord, that hence we hold that the applicant has failed to prove the victim died as a result of fall from
Okay,
the
which
train.
rules you are relying upon?
Rules, my lord, 1, 2, 3, 3, 2. Section.
Okay, section is there. Rules. Inquiry rules, any?
Inquiry rules not challenged, my lord. Only, my lord, section
Okay,
is
section,
there.
that is there.
My lord, I am also giving the Rina Devi judgment. Entire explanation is there.
Okay, I conclude the hearing then. Yes, record and order.
My lord, just one point I am adding, what they are telling, that the Caesar list was an afterthought. It was not prepared in the due course, but that is not true. In the investigation report, which is page 70, the case reported on 9:55 p.m. Case reported 9:55 p.m. Investigation commenced 9:55 hours. Investigation closed 11:45 hours. রাত পৌনে 12টা, your lordship, 11:45 hours. And the Caesar list is prepared within that period. 11 during the completion of the inquest report, the Caesar document was prepared. It was not that after 1 hour, after 2 hours, it is prepared. It was well prepared at the spot.
Okay, record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 23/6/2026.
Grateful, your lordship.
Claim case bolun, both sides present. Item 6.
6 and 7.
It's my appeal, my lord. It's a very short matter. We have preferred this appeal on the point of fake driving license. There was evidence on behalf of the insurance company. Learned trial judge, my lord, observed that we should get the right of recovering the awarded sum from the owner. But in the ordering portion, my lord, that is not there.
Let us see this.
My lord. And I have served upon the owner also. This is my affidavit of service.
Kindly come to page 55. So let us see, just a minute. Have you paid the compensation amount?
No, it's my appeal. I have deposited. It's under section 163A. At page 30, my lord will find that the driving license of the driver, the driving license of the driver, it had been seized.
Yes.
At page 30, my lord.
Yes.
30.
Yes.
And our evidence, my lord,
Page.
insurance company's evidence at page 46, that is exhibit B.
40.
OPW, before that, I'll just take my lord to the evidence of OPW 1, my lord. It is at page 21. The employee of the motor vehicles department, my lord, page 21.
Yes.
The employee, he came and he deposed, my lord. He produced two exhibits. One is exhibit A, which is the authorization letter, and the other is the report, my lord, which was issued in respect of the driving license of the concerned driver.
This is page 20.
Page 21. Page 21, the relevant portion, my lord. I am an employee of motor vehicles department, presently attached to Tamluk District Magistrate's office as inspector. The cross-examination, I'll straightway go to, my lord. It says that we did not find any information regarding driving license number such and such in MV department Tamluk. So as far as the driving license of the concerned driver is concerned, no information was found regarding that particular driving license, my lord.
So that driver was examined?
No, driver was not examined, my lord.
But the vehicle owner?
He probably did not contest. I'll just check.
Expired, lordship. No, vehicle owner was examined by you or not?
No.
Driver was also not examined?
No. Exhibit page 46.
Let us see the driving license. What is the observation?
Yes, at page 46, my lord will kindly come to.
Page 55 is the judgment. Okay, page 46.
It's exhibit B that I was referring to by insurance company.
Yes.
It says that in compliance with order reference mentioned above, this is to inform you that there is no driving license as DL number such and such as noted in the summon. Now, page 55, my lord, as I was saying, last paragraph. Has my lord found it?
Yes.
It is now settled law that although the offending driver was not holding a valid driving license at the time of accident, the insurance company shall pay compensation amount and shall be at liberty to recover it from the owner of the vehicle. But this observation, my lord, it's not there in the ordering portion. Page 58 is the ordering portion. My lord will kindly come to this page 55 regarding valid driving license, my lord.
Yes.
With regard to valid driving license of the driver of the vehicle bearing number WB296001, the OP Insurance Company has produced a report issued by licensing authority MV Department Tamluk, and the same is marked as Exhibit B. From Exhibit B, it is proved that driving license number such and such was not valid. Now, the question is whether in absence of a valid driving license, whether absence of a valid driving license can absolve the insurance company of all its liability to pay compensation. I think thereafter one judgment was cited, and thereafter the learned trial judge held. I think the decisions cited by the learned advocate for petitioners are very much applicable to the facts and circumstances of this case. It is now settled. So it was held that the driving license was not valid, And thereafter, somehow in the ordering portion, my lord, I only pray for my right to recover, my lord, in accordance with law. If it is found, once again, that the owner was not aware, my lord, about the fake driving license, and my learned friend has come up for enhancement, my lord, he prays for 5 lakh. His cross objection. Since I had given evidence, my lord, and I had also served upon the owner, thrice I have served during the pendency of this appeal
Let me
also.
remit the matter back regarding reconsideration of this issue. Okay, examine the owner and the driver. Okay, I am remitting the matter, keeping the matter pending, giving you a limited scope.
Kindly, if they able to prove that the driver was a valid driving license, when the someone has come before the learned tribunal, is the an officer of the has come and proved that not valid, and the observation of the learned tribunal is that the offending was not valid driving license, so liberty to recover. So the recovery right already been given, but they are not challenging the validity of the judgment of the learned tribunal. They are challenging that ordering that portion not reflecting in the ordering portion. But lordship, for the reason the claimant will not suffer. But they are not challenging the judgment is the null and void.
May I?
They are only saying that no,
let them examine it.
May I?
Better, you see.
Lordship, can you allow the claimants to withdraw?
I am allowing you to withdraw a part.
Excellent.
Let this matter be kept pending. You
My lord,
withdraw a part of the amount.
Lordship, may I just suggest one thing? If my lord will not take me amiss, my lord will dispose of this appeal, my lord, and my lord will grant me the liberty to proceed against the owner in accordance with law, with the catch that I have to prove my case once again before the concerned court.
Yes, that can be. That can be.
If my lord so desires, my lord may kindly, I think that will be better. The appeal will also be disposed of, and I'll also get the right of recover, provided I can prove my case. So I can, in that case, my lord, I can very well call the driver and the owner.
Yes, regarding cross objection.
That is for 5 lakh, it's 163A.
Settled law, there is 5 lakhs.
Yeah,
Awarded lordship, only awarded
3,88,500 was granted. He pays for 5 lakh.
balance amount they will deposit. It's a bit 40 crore.
Yes, record an order. Learned advocates for the parties at present are learned advocates. The appellant before this court was an opposite party, insurance company, a claim under section 163A of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award passed by Learned Additional District Judge Haldia Purbo Medinipur in MACC 7 of 2017. Stop. The respondent number 1 and 2 claimants before the Learned Trial Court have also filed an application for enhancement of the compensation. The ground of challenge in this appeal by the appellant insurance company is that the Learned Trial Court, although came to a findings that the driver of the offending vehicle was not having a valid license, and further observed that the appellant insurance company is entitled to recover the compensation, but the same liberty is not granted in the order of compensation. Now, Learned Advocate submits that once it is held by the Learned Trial Court that the driver was not having valid license, the appellant insurance company is entitled proceed against the vehicle owner for recovery of the compensation amount in accordance with law. Stop. Learned advocate for the respondent number 1 and 2 claimants, although does not dispute the submissions of the learned advocate for the Appellant Insurance Company Limited, but submits that the compensation claim is under section 163A of the Motor Vehicles Act 1988, and under the amended provision, the claimants are entitled to rupees 5 lakh, which the learned trial court erred in not awarding. Stop. Upon perusing the award passed by the learned trial court and considering the provision of section 164,
163A amended.
163A,
The notification.
Amended 164 of the
Amended 163A.
no, 163.
The notification. That will be applicable in this case.
The amended provision of section 163A
My lord.
of the Motor Vehicles Act, the amount of compensation shall be rupees 5 lakh. Thus, the respondent number 1 and 2 claimants are entitled to rupees 5 lakh from the appellant
Oriental
Insurance Company Limited. Stop. With regard to the principles of pay and recovery, it appears that the learned trial judge did not grant the recovery of the compensation amount from the vehicle owner, being the respondent number 3 in the instant appeal. Stop. In the case, thus, in order to recover the compensation amount from the vehicle owner, the principles as laid down in the decision of Lidza BB versus Oriental Insurance Company, being FMA dash, should be followed. In the case of Lidza BB, it was observed, quote, thus, the observation made in the case of Lidza BB should be followed by the Appellant Insurance Company to recover the compensation amount from the claimants, from the vehicle owner. The respondent number 3 hearing, the respondent number 3 hearing shall be given an opportunity of being heard before a decision is taken in this regard. All relevant points are kept open before the learned trial court, stroke executing court. As this appeal stands disposed, the so enhance
I have to deposit.
The appellant insurance company shall pay rupees 5 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Such payment shall be made by depositing before the Registrar General, High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the balance amount be deposited within 8 weeks. The claimants, respondent number 1 and 2, will be entitled to withdraw the compensation upon compliance of necessary formalities.
I'm extremely grateful, my lord.
So appeal and cross appeal are disposed of.
Yes, both FMA 144 of 2026 along with COT 30 of 2026 stands disposed.
I'm grateful, my lord. Deeply obliged.